item number 49, madam. Let the matter be taken up hearing at 2 p.m. Highly obliged.
May I please, Your Lordship, my Lord? My Lord, I have prayer in item 33, my Lord. In this case, my Lord, city was called for on 2 occasions, my Lord, giving the reminder. But unfortunately, my Lord, charge sheet has been submitted, my Lord. The affair was lodged on 16th of June, my Lord, very recently. my Lord.
What is your prayer now?
That Lordship will kindly, I'll approach the, my Lord, concerned court below, my Lord.
Okay, you are withdrawing it.
Yes.
Heard Mr. A.
Z. Aman.
Z. Aman,
Yes, my Lord.
learned counsel for the petitioner. Z. Hamad,
Yes, my Lord.
learned counsel for the petitioner. Who prays for allowing the petitioner to withdraw the instant anticipatory bail application. The prayer is allowed. This anticipatory bail application is dismissed on withdrawal.
Lord, liberty may be granted if, my Lord, necessary.
Liberty not necessary. in
Well, not
criminal
necessary.
cases.
I'm deeply.
Wait, please, Lordship. Lordship, item number 17. LCR has received by the registry, but it has not been tagged. So kindly call for the LCR.
Yes, sir. Okay.
Apply.
7.
Make the Lordship. Item number 28. Kindly adjourn the matter.
28.
8. Kindly adjourn the matter for the day. Here is the interim.
Why are you praying for adjournment? What is the reason? You have to mention reason, then you have to make prayer.
Call for CD. I think CD has not.
CD not with him.
Okay.
He has not come.
Heard. What is your name?
In Islam.
Heard Mr. M. N. Islam, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor, who prays for some more time to produce the case direct. Prayer is allowed. Let this matter be listed again on 23rd of September. The interim order shall continue till next day.
Hello, Lordship.
May I please, Your Lordship, with the consent of the other side, I beg to mention item number 29. Your Lordship, we have not received instruction and Your Lordship may adjourn the matter for the day. And fix this
29,
matter after 3 weeks, Your Lordship.
29.
Yes.
Heard Miss, what is your name?
R. Hussain, Your Lordship.
R. Hussain, learned counsel for customs, who prays for some more time for this, who prays for an adjournment on the ground that she has not yet received the necessary instructions from Customs Department. Mr. S. Munir raises no objection to the prayer for adjournment. Hence, the prayer is allowed. Let this matter be listed after 3 weeks on a date to be fixed by registry. The interim order shall continue till next day. 3 weeks, what is the date? 18th, on 18th September.
Yeah, please, Your Lordship, my Lord. Lordship, I beg to mention for withdrawal of a anticipatory bail application, Lordship. Actually, my client, as per my instruction of my client, they want to.
When you want it? Tomorrow. Okay.
On withdrawal, Lordship.
It is not yet listed. It has to come. So tomorrow, you give the mention memo. It will be listed tomorrow.
May I please, Lord, we are praying for listing on your bail matter for motion. Carry it one day after tomorrow.
When have you filed?
22/8, Lordship. Last Friday.
It has not yet been listed.
No, well, not yet numbered also.
Why?
My Lord, you. Monday was
There
holiday.
must be some defect in your filing.
No, we have examined, not yet only reported also. Not shown in online that it is under defective.
Okay.
On tomorrow, day after tomorrow.
Day after tomorrow.
Obliged.
If it is free from defect.
Fine.
Yes,
Obliged.
please, Your Lordship. I beg to mention item number 20, Lordship, bail application, and his diary has been received, but Lordship, some instruction is awaited, so I pray to fix the matter on Friday, Lordship.
20.
20.
Heard Miss N. Chaudhary, learned counsel for the petitioner, who prays for an adjournment on the ground that she has to receive. He needs some instructions from the petitioner pertaining to this case. The case diary is there.
Yes, my lord.
Mr. K.K. Parashar, learned additional public prosecutor, submits that case diary has been received. Stop considering the submissions made by learned counsel for the petitioner. The prayer is allowed. Let this matter be listed on Friday. Select date due. Second of September. 4th of September. The case diary shall be retained till next day.
May I please your lordship, we are called mistake lordship for withdrawal lordship. Withdrawal lordship.
Okay.
Another one lordship, the motion meta lordship. Yeah. lordship.
When have you filed?
We have lordship 22/8. I have checked the lordship, the no defect. Lordship, day after tomorrow lordship.
Okay, day after tomorrow, if it is defect free.
Lordship.
May I please, Lordship? I need to mention item number 35. Engaged counsel Mr. A.K. Azad is out of session. Matter may be kindly adjourned for the day, Lordship.
You have informed the other side.
Yes,
I am for the respondent number 2.
Heard Miss, what is your name?
C. Kolita on behalf of.
Heard Miss C. Kolita, learned counsel appearing for Mr. A.K. Azad, learned counsel for the petitioner who prays for an adjournment on the ground that the conducting counsel for the petitioner is out of station. Mr. S. Munir, learned counsel for respondent number 2, has no objection to the prayer for adjournment. Hence, same is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
One a bail application law. So listed on last 2nd of June. Therefore, it is not listed. Can be on Friday.
Friday. 3rd of September.
Another milord, it is new filing milord, filed on 22nd of August. Not listed. So it can file Friday or Monday.
Friday, if it is defect free.
The defect I have seen, there is no defect.
Okay. Friday.
May I please, Lordship, I beg to mention for listing one criminal petition, Lordship. It was earlier listed but not reached, Lordship.
Pray before registry.
May I please, I beg to mention, to list the matter, your lordship, unlisted motion, your lordship. So the matter is.
What is the matter?
Matter is AB, your lordship, and there is a cross case and I am a subject matter of a higher secondary and
When have you filed?
lordship, today I itself, I have serial
No,
number, your lordship.
what is the urgency?
Urgency is that the police is searching the petitioner as well as the family member and
Have
the
you
relative.
approached the sessions court?
No, your lordship. There is
Yes.
no chance of to go there and that is why they are afraid of the and in the locality, so they have come here, your lordship, before your lordship. So the kindly maybe allowed to stay,
Tomorrow.
if possible, if lordship.
Tomorrow, otherwise it will come in its due course.
Lordship,
Tomorrow.
Okay.
There will be application. Hardly I regret that.
Case diary would be required. Heard Ms. T. Som, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Call for the case diary. Place this matter on.
Hailagandi milord 9.
No, not Hyderabad. This is from CID, Cyber. Ulubet.
Sorry.
Putul suggested it. 4th of September.
Yes. It is okay.
Of like that.
Item 2.
Your lordship, this is a POCSO matter, your lordship.
Heard Miss N.K. Brown, learned legal aid counsel appearing for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. Under investigation or charge,
Charge sheet file, trial has submitted.
let the notice be issued to respondent number 2. And let be, whether scan copy of the case record would be required.
Charge sheet, in the charge sheet, 8 witnesses, your lordship.
On what ground you are seeking bail?
Your lordship, there is discrepancy in her deposition before the magistrate as well
Let
as.
the scan copy of the
I have annexed the
deposition you have annexed. Okay. Scan copy now. The petitioner shall take steps for issuance of notice upon the respondent in pursuant to the prevailing notification of the registry in this regard within 3 days from the date of this order, returnable on 11th of September.
My lord, she said for regarding discrepancy, my lord, discrepancy may be in 183 and
Your
deposition.
lordship, I have annexed both.
183 also, okay. List accordingly.
Here only one section is non-bailable. 3363. Maximum punishment is 7 years. And inside for 41 days. One of our prime contention is that 35 notice were not served before arresting us.
We call for the case hearing.
Can you give us a short date, and
Okay.
at 41 I may be looked into.
Heard Mr. N. Mahajan, learned counsel for the petitioner, also heard Mr. K. Parashar. Call for the case hearing. Let this matter. 8.
I think it will be it is 41 days.
Short. 3rd of September.
Obliged.
Item 4.
May I please? This petitioner, he is in custody for 25 days, my lord. In a nutshell, the allegation that for the purpose of my lord tax evasion, he has procured used one particular bank account from somebody else. And he has used to deposit his money in that particular account. Then in that particular account, somebody else has also deposited, and that amounts to be some money laundering, right? That's the basic allegation, my lord, at this stage. But all the charges, my lord, all the section, my lord, below 7 years, my lord, lordship kindly turn to page 27. Forwarding report of the accused. Ground of arrest is given. But regarding the
Case diary would be required.
notice is regarding, my lord, the notice.
Case diary would be required.
Notice here, my lord. No
Notice under
No notice, 35.
35(3).
35 notary, no notice at all. Directly arrested, my lord. The absolutely no whisper in the forwarding report.
Whether any reason has been mentioned.
No, nothing. No whisper here. No reason, nothing about why it was not given or why it has been arrested without notice. Not a single line.
What magistrate has, while forwarding,
That I don't know, but first of all, the requirement of these, he has to satisfy. The magistrate may give the different reason, but it is the incumbent on the police officer. If he doesn't give any reason, how the magistrate will come for his own reason? First of all, magistrate has to satisfy himself from the reason given by the police. If the police does not give any reason, there is no question of giving the subsequent reason by the magistrate, my lord. It is the duty of the police that because of the reason I have not given the notice. That reason is not there. He has not given the note, absolutely silent. Why he has not given the notice? Absolutely silent. In that case, the magistrate, he may find something, that's a different issue. But that has to come from the reason given by the police, that I am not, this is the reason why I have not given the notice. But here, absolutely silent. Why this mandatory? He can arrest it, but he has to give reason. Without notice also he can arrest it, no problem on that. But he has to give at least one reason, ground and the reason.
No, in the grounds of arrest,
Yes, grounds of arrest, yes. But
Number
why
3.
notice? I'm talking about the notice. Why notice was not given?
where is the requirement that notice has to
In
35,
case of the
35(3) itself?
it says that when in case of a 7 years, he can issue the notice, first of all, and if he
What
doesn't,
Anesh Kumar says,
yes, if he doesn't give the notice, he can arrest it. But that has to be give a reason,
reasons for not giving
not
notice.
giving notice.
Where is that?
That is not here.
No, no.
That is the until and the honest Kumar.
Yes, show me that.
Until to. The honest Kumar has been quoted, my lord.
That
Paragraph 27. It has been in the until minus Anesh Kumar has been quoted. From the plain reading of the aforesaid provision, it is evident that the person accused of an offence punishable with imprisonment term which may be less than 7 years or which may be extended to 7 years, with or without, cannot be arrested by police officer only on his satisfaction that such person has committed the offence punishable as aforesaid. A police officer before arrest in such cases has to be further satisfied that his arrest is necessary to prevent such person from committing any further offence or for the purpose of investigation of the case, or to prevent the accused from causing the evidence on offence to disappear, or the tampering of such evidence in any manner, or to prevent such person from making any inducement, threat, or promise to a witness, so as to dissuade him from disclosing the facts of the court to the court and the police officer, or unless such accused person is arrested, his presence in the court wherever required cannot be ensured. So this is the requirement, my lord. These only this condition he can arrest, my lord. But these are the conclusion which may reach based on facts. So these may be the grounds, but it has to be based on facts. That facts has to be in the form, my lord, that this is the reason that has to be intimated to the court in the forwarding that this is the reason. That's why now the law mandates that the police officer to state the facts and record the reasons in writing. This is important, in writing, which led him to come to the conclusion covered by any of the provision aforesaid. If the any of the provisions.
no, but here
he has given the grounds of
no, my query is, suppose in a case where the punishment is not more than 7 years.
Yes.
And the law says that 35(3) notice has to be given. If police chooses not to give that notice, your submission is that he has to
give the
give the reasons in writing why he is not issuing.
Yes, my lord.
Where is that requirement?
So that's requirement is if that's the reason, my lord. He has to, if he doesn't, that is the, I'll come to that, my lord. The law mandates the police officer to state the facts and record the reasons in writing. Record the reasons in writing.
For his arrest.
Yes, that is, these are the reasons. That is why I have arrested him.
Those reasons
Yes.
he has mentioned.
Some reasons has been mentioned. These are the grounds.
No,
The
no,
reasons
my
is
query
different.
is reasons for not giving 35(3) notice.
First of all, that he has committed, these are the grounds, these has committed, these are the prima facie, these are the grounds. But the ground has to be based on certain facts. As they said, these are the conclusion which one may reach based on facts. Now, the law mandates that the police officer to state the facts and record the reasons in writing which led him to come to the conclusion covered by any of the provision. That means he cannot be, may not necessary to give the notice. He can arrest me on this basis of these grounds. If it exists, any of the ground. If any of the ground incorporated in here, it exists, he without notice, he can arrest. But after arrest, my lord, it is mandatory for him to inform to the court that I have found these are the grounds and these are my reasons. That's why I have arrested him. That is the necessary. Notice is not mandatory on all cases. Without notice also he can arrest, provided he has to satisfy that out of these, any of the ground exists and their facts on the basis of that particular ground has. Now the the law mandates the police officer to state the facts, record the reasons in writing, led him to come to the conclusion covered by any of the provision aforesaid. That's important. So he have to give a conclusion in the forwarding why he has arrested him. Notice is not mandatory in that case, but reasons he has to give it to the court. That is, he cannot bypass while making such arrests. Law further requires the police officer to record the reasons in writing for not making the arrest also. If he doesn't arrest after the notice, he also has to intimate to the court that this is the reason. I'll come to that. The pit and court that the police officer before the arrest must put the question to himself, why the arrest? It is really required that the purpose is all served, that the object will be achieved. It is only for these questions or the address, one or the other condition enumerated above is satisfied. The power to arrest needs to be exercised. In fine, the before arrest, first of the police officer should have reason to believe on the basis of aforementioned material that the accused has committed the offense. Apart from this, police officer has to be satisfied further that the arrest is necessary for one or the more purpose envisaged by subsection A to E of the clause 1 of the section 41E. So if that exists, my lord, that has to be, he has to give us reasons. Now, next, my lord, 8.2, then the magistrate, it's a duty of the magistrate to satisfy himself. Now, that's not important, my lord. Here, it doesn't come because he has not given the any record. Why? In fine, up to 8.4, my lord, it is the duty of the magistrate. Now, 9, the aforesaid provision makes it clear that in all cases where the arrest of a person not required under section 41(1), the police officer is required to issue notice directing the accused to appear before him at the specified place and time. Law obliges such an accused to appear before the police officer, and it further mandates that if such accused complies with the terms of the notice, he shall not be arrested unless the reason to be recorded to the police officer in the opinion of the arrest is necessary. It is the stage of also the condition precedent for the arrest envisaged on section 41 CRPC has to be complied, hence will be subject to the same scrutiny of the magistrate as aforesaid. So first of all, it is the incumbent on the police officer, if he arrests on these particular grounds, that has to be, he has to satisfy.
Now in this case, he has
Yes, he has given some ground.
7 grounds.
Yes, 7 ground, but he has not stated anything that these grounds existence from these are the facts. Where from I come to, that's why I have not given the notice. These grounds are allegation. Allegation may be there. There may be hundreds of allegations, but he has to come to an finding, a reason of his from the basis of facts. And he has to say that these are the, because of these reasons, I have not given the notice. That's the now, Lordship, can I see 10 is also very important. We are of the opinion that if the provisions of section 41 CRPC, which authorize the police officer to arrest an accused without an order of the magistrate and without a warrant, are scrupulously enforced, and wrong committed by the police officer intentionally and unwittingly would reverse the number of cases that come to the court to grant the anticipatory bail and be subsequently reduced. We would like to emphasize that the practice of mechanically producing the case diary all or most of the reasons contained in section 41 CRPC for effecting arrest be discouraged and discontinued. So simply incorporating the reasons from 1 to E is not the sufficient. The reasons is more important. In the
Where is the
1 to E lordship will-
order of remand?
that is the order. This is order of remand is I have. there's no
That is necessary.
Because my contention is that, my lord, order of remand will come subsequently. But if the forwarding report does not say anything why he has not given notice to me. And
No,
if he has not
but
given any
unless
reason,
the remand order is before this court,
yes, that's true, but
how will I
no,
consider?
that will come, my humble understanding, my lord. If he doesn't give any reason, the police
For
officer doesn't
dispensing
give
with-
any reasons in the forwarding, where is the question of taking the cognizance on that facts? He will take the magistrate, definitely will take the cognizance on the facts, on the reasons given by the magistrate. That's the law. Because that's the law says, the magistrate, what magistrate will do? The before magistrate authorized the detention under section 167, he has to first satisfy that the arrest made is legal in accordance with the law and all the constitutional right of the person arrested is satisfied. So this is not done here. No reasons has been given. If the arrest is effected by the magistrate does not satisfy the requirement of 41 of the code, magistrate is the duty bound to authorize the further detention and release the accused. In other words, when an accused is produced before the magistrate, police officer effecting the arrest is required to furnish magistrate the facts, reasons, and its conclusion for arrest. Where is these, my lord? First of all, facts, then reasons, and its
Facts,
conclusion.
the magistrate will ascertain the facts from the case diary.
Yes, facts, not only facts, my lord, facts, comma, reasons, and its conclusion. For the arrest, and the magistrate in turn is to satisfy the condition precedent for the arrest under section 41 CRPC has been satisfied, and it is therefore, thereafter, he will authorize the detention of the accused. The magistrate, before authorizing detention, will record his own satisfaction, maybe in brief, but the said satisfaction will reflect for his order. It shall be never been based on the ipso dixit of the police officer. For the example, this is important. In case of a police officer considered the arrest necessary to prevent such person from committing any further offense or proper investigation of the case, or for preventing the accused from tampering with the evidence or making inducement, etc., the police officer shall furnish to the magistrate the facts, the reasons, and the material on the basis of which police officer had reached its conclusion. So that's very important. Simply giving the grounds will not do. He has to give the basis on which he has satisfied that yes, this material exists.
Yes, Mr.
Then,
Parashar.
and then, my lord, also, and shall be perused by the magistrate while authorizing. So if it is not given to the magistrate, there is no question of magistrate to take the cognizance which is not there itself. Wherefrom he will peruse, my lord? If there is not, nowhere has been mentioned, no conclusion, no facts, no reasons, magistrate of his own cannot. First of all, that requirement is that it must exist in the forwarding. Then only the magistrate can peruse that. He need not to go into the brief, but his satisfaction is different. But there has to be some grounds at least that these are the grounds, and I am of the opinion because of these reasons, the arrest is necessary. At least one line. There's nothing. If there is nothing, where from the magistrate now will sit over there, he will give a different reason and his satisfaction. That's still not law. Magistrate will decide on the basis of the reasons given by the police, whether reasons are sufficient. The
Yes.
lordship has already
My lord.
decided this point in one of the cases, my lord.
Yes.
If the forwarding report does not say he was released on bail.
From my understanding, my lord, I am.
No,
I-
Mr.
my lord,
Parashar,
only one
I
line.
have a query. In this case, all the
Grounds that we-
offenses involved does not entail punishment more than 7 years.
Yes.
Therefore, 35(3) says that notice has to be given under 35(3).
Yes.
If police is
In
of the
35
view that
35(3) notice has
notice
to be
is to be
given,
dispensed with,
if arrest is not necessary.
that has to be reasoned out.
Yes.
That
reason.
for this reason, 35(3) notice
Yes,
is not given.
In the forwarding report, I have done, go by the forwarding report, it is not mentioned, but one thing is, that, my lord, from my understanding, my lord, the police, 35, section 35B, Roman 1, the police officer has reason to believe on the basis of the such complaint, information or suspicion that such person has committed the said offense. Now, he has to believe himself that he has committed the offense, and subsequently the police officer satisfied that the such arrest is necessary. Then yes, reason has to be given to the by the forwarding, my lord. But in the case that he may be in some, my lord, maybe
But in forwarding, there is no mention.
forwarding details grounds has been given. More than crores of money has been involved in this case, my lord. More than crores. He has
These are the
deposited-
grounds. I am satisfied.
Yes.
The grounds is different, my lord. Ground of arrest is different, but reason for arrest, that yes, he said that suppose there's an allegation that he may abscond, but that will not sufficient.
No, but
35(3) will come, my lord, if arrest is not necessary.
we are calling for the case diary because remand order is not before this court, which was necessary.
Remand
Lordship
order
will decide, but
maybe
my
some
contention is that remand order will come subsequently
Okay.
because of the simple fact, when there is no reason at all, from where the magistrate will come to his own finding, when there is no reason at all.
Where is which police station? How much time it will take?
Bilasipara, my lord, Dhubri.
Heard
Support,
Mr.
support.
A. M. Bora, learned senior counsel assisted by Mr. V. A. Chaudhary, learned counsel for the petitioner. Also Mr. K. K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Syed Javed bin Zia alias Javed, who has been detained behind the bars since 3/8/2025 in connection with Sapor PS case number 119/2025 under section 61 within bracket 2/318 within bracket 4/336 within bracket 3 of BNS 2023. Learned senior counsel for the petitioner has submitted that all the offenses involved in this case prescribes punishment not more than 7 years, and therefore he submits that the notice under section 35(3) of BNSS ought to have been given to the petitioner before he was arrested. He submits that if the arresting authority chooses not to give the notice under section 35(3), it ought to have mentioned the reasons for doing so in the forwarding report to the magistrate while forwarding the petitioner after his arrest. Learned senior counsel for the petitioner submits that in the forwarding report, though grounds of arrest have been mentioned, however, there is no whisper as to why notice under section 35 within bracket 3 of BNSS was not given, though the offenses involved in this case prescribes punishment not more than 7 years. He submits that there has been violation of the guideline of the apex court in the case of apex court given in the case of Anesh Kumar versus What is the citation?
State of Bihar.
Anish Kumar versus
State
State
of
of
Bihar.
Bihar. Report
14, 8 SCC, my lord.
reported in 2014 8 SCC
273.
273, as well as in the case of Satinder Kumar Until versus Central Bureau of Investigation and another, reported in 2022 10 SCC 2020 10 SCC 51. Stop. Though the submissions of learned senior counsel appears to have some force, however, the remand order by which the petitioner was remanded to judicial custody by the learned magistrate is not on record, and therefore this court intends to peruse the same before considering the bail application. The perusal of the case diary is also felt necessary in this case. You will produce remand order?
Will bring the certificate.
Along with
CD will come, my lord.
In CD, it may not be there. Remand order,
Will apply.
okay. Let the case diary be called for. When?
Fourth, my lord.
Let this case be listed on
Fourth September.
4th of September.
Can it be on third, my lord?
3rd of September. Then its senior counsel submits that he will submit the certified copy of the remand order before this court on the next date fixed. List accordingly.
Right. Okay.
May I please your lordship. It's a regular bail application, my lord. And police station is Dispur, my lord. And they are under custody in 135 days today. Cyber crime.
We'll call for the case diary.
Yes, sir.
Heard
Dispur
Miss-
police station.
Heard Mr. M. Nath, learned senior advocate, assisted by Mr. A. Bhattacharya, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor, call for the case diary. Please this matter when? Second, on 2nd of
second, fine.
September.
Published.
So this is second bail application, madam. Today, 89 days, madam. And section, madam, 316, subsection 5.
Case diary is there.
And madam,
You take instruction whether charge sheet has been laid on.
For other cases, yesterday's item.
Konkon Das, okay. Tomorrow we'll fix it.
madam, otherwise, madam, if I am understand properly the section 316(5) for a moment, madam.
Not today, tomorrow. Heard Mr. N. K. Kalita, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor, who submits that some of the bail application filed by the co-accused arising out of same police station case is listed tomorrow. And therefore she prays for listing this matter along with the said bail application tomorrow. The prayer is allowed. List this matter tomorrow, that is on 28th.
Published. May I please your lordship. Lordship, regular bail application, lordship. As per FIR, lordship, offence under section 354A, 354C, 366, 376, 2 and 385 IPC. Read section 6 of POCSO Act, lordship.
Notice will go.
Lordship, may I submit one thing, lordship?
Yes.
Permits, lordship. Lordship, the present accused petitioner has married the victim girl, lordship.
Married.
Married the victim girl before lodging the FIR, lordship. And lordship, the alleged victim girl, lordship, at the time of lodging the FIR, lordship, she was aged about 18 years, lordship.
Where is she now?
Now she is with the present accused petitioner, lordship. They have
No,
one
but you
child
are in
also,
jail.
lordship.
How she can be
Now-
with him?
Now she is in lordship, accused petitioner's house, lordship. Now she is in accused petitioner's
Let
house,
her,
lordship.
Let her appear. She is entitled to get notice.
And Lordship, birth certificate also annexed Lordship, as per school certificate Lordship.
No, let her appear. If she appears, we can,
Can fix a short date Lordship.
Okay.
Accused has been arrested on the
okay.
strength of NPW Lordship.
Mr. T. Thakuria. This is a pending case and this charge sheet has been laid.
Charge sheet late Lordship.
Yes, sir.
He was arrested on the strength of NPW Lordship.
Oh. Since when you are behind the bars?
Lordship. Before
No.
lodging the FIR Lordship. FIR was lodged on Lordship
Okay. Heard Mr.
27/2023.
Heard Mr.
Lordship.
T. Thakuria, learned counsel for the petitioner, also heard Mr. N. Das, learned additional public prosecutor. Since this case involves offense under POCSO Act, let the notice be issued to the respondent number 2. Stop. Learned counsel for the petitioner submits that respondent number 2 is the wife of the present petitioner.
Lordship, respondent number 2 is the father of my victim.
Oh, sorry. The victim girl is the wife of the present petitioner. Father is opposing.
Father is opposing Lordship.
Oh, they,
But Lordship, victim girl is major Lordship.
the petitioner shall take steps for issuance of notice on the respondent number 2 by registered post. No, as in pursuant to the prevailing notification of the registry in this regard, within 3 days from the date of this order, returnable on 10th.
Lordship, kindly fix a short date Lordship.
Suggest,
We have one minor.
suggested it.
4th of September.
Court whether notice will be
On the
served.
next day,
From
Lordship,
Bhopal.
victim girl will appear Lordship.
Victim girl's appearance is not necessary. The informant has to, respondent number 2 has to be notified.
On 5th of September, Lord.
Yes, Lordship, long date Lordship.
On 5th,
Master.
Item 47 from supplementary list.
We have pre-arrest bail mallet. Then present petition is a doctor or a dentist mallet, BDS. Annexure 1, page 18 is the affair mallet. But this affair laws before the DGP mallet. Sum and substance mallet, I have a fraudulent registration, I am
page number,
page 18 mallet. Page 18. This is the- So 1 minute. But I am not traveling, reading entire FR, it's a long, well drafted FR. Well, just.
from where you have done your BDS?
Kalka Medical College. Well, I am coming, all this I am coming. Subject matter, complaint.
Are you registered under Assam Dental Council?
No, well, that is their crux matter. It is not required as per 46 of the Dentist Act, as well as Dental Council of India has clarified. I have annexed all those. I have already arrested Malay. In other case, this honorable court release on me bail Malay. Just I am coming for a moment, Malay.
It is required here.
Malay, page 18, Malay.
Yes.
Complaint action such and such for fraudulent registration and practice as a dental surgeon in the Borpeta district of Assam. Now I am not reading all these same things, my mark sheet and certificate number be enrolled. Now I take a lordship annexure 2, page 22, my. This is the subsequent affair, my lord. By virtue of this affair, I have arrested. And I take a lordship, page 22.
Yes.
That is, my lord, the petitioner has been arrested. Now I take a lordship, the forwarding report, page 24, my lord, of that case in which I have arrested.
This page 22 is,
My lord, subsequent affair, my lord. Page 22. By which I was arrested.
in this case,
Other case, my lord. I am before your lordship, a Howley PS case number 129. And subsequent case,
Where is the affair of that case?
my lord, that is page 22, my lord.
Page 22 is Borpeta PS case number,
My lord, in that case, I was arrested.
and in Howley PS case number, you are apprehending your arrest.
Arrest.
Where is the affair of that case?
My lord, page 18, my lord. Page 18, my lord. This is the affair against this present. case.
Okay.
Now I take a lordship the forwarding report. Page
Forwarding of the earlier case.
earlier case, my lord.
Yes,
It is mentioned, my lord, paragraph 2, my lord, page 24, my lord.
yes.
During investigation, your lordship got in, my lord. Page 24, paragraph, second paragraph, my lord.
Yes.
During investigation, it has been found that there is already another case has been registered against the accused as Howley PS case number such and such 129/2024 under section such and such for the same reason. But the crux of the whole allegation is dental fake registration, fake. Now I take your lordship. Against this case, my lord, I approach before the honorable court, page 26, annexure 4, my lord. On the motion itself, my lord, this honorable court was pleased enough to allow me an interim bail, my lord. Normally, my lord, now interim bail, considering the authenticity, my lord. I am coming on the later on, my lord, all this. Release me on bail. Now, accordingly, I appear before the now. When I appear before the police station of the Borpeta, my lord, as per direction of the honorable court, now in the year of 2024 case, my lord, now I take a lordship annexure 5 page 29. I'm showing my certificate and academic qualification, mark sheet, etc.
No, whether registration at
Other dental,
Dental Council of Assam is necessary.
no dress.
Show me.
My lord, Dentist Act. And this has been already clarified by the Dental DCI, Dental Council of India. But I have annexed that report also.
Lordship, the document certificates you have submitted of Kalka University, that certificates are also not genuine, Lordship.
My lord, I am coming later. My lord, same
Oh.
As
case,
per the allegation,
petitioner
that
has already been
certificates are
arrested and
also
released.
not genuine, Lordship.
My lord, I am coming now.
Yes.
My lord, page 30 of the book, my lord, 46, my lord. Any person who is registered dentist, registered dental hygienist, or registered dental mechanic in a state may practice as such in any other state.
Where have you been registered?
My lord, in Maharashtra. Now I am coming to all the my certificates. Annexure 5, page 29. Now. This is the my lord first my BDS mark sheet, my lord. Chaudhary Charan Singh University, page 25, my lord. Page 29. Annexure 5.
Where is your registration?
My lord, I
certificate?
mean one by one. My lord. Second, my lord, page
No,
30.
not one by one. Come directly to
My
that.
lord, registration is my lord. Page 37, annexure 10. My lord, I have all the original with me, my lord. Page 37, annexure 10. My lord, this is the registration. Now followed by annexure 11, page 38. It is up to date, valid, my lord. My lord, like we, the advocates are required after every 5 years,
Okay.
renewal of the registration.
We are calling for the case diary. In the meanwhile, let him cooperate in the investigation. Heard Mr. A.K. Hussain, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor. this application under section 482 of BNSS 2023 has been filed by the petitioner, namely Ziarat Hussain alias J. Hussain, who is apprehending his arrest in connection with Howley PS case number 129/2024 under section 419/420/468/471 of the Indian Penal Code. The gist of accusation in this case is that on 24th July 2024, the Registrar of Assam State Dental Council had lodged a complaint before the Director General of Police, inter alia, alleging that the present petitioner has been practicing as dental surgeon by showing fake registration certificate. No, but Maharashtra Dental Council itself has clarified that in the FIR, read para 3.
That is wrong.
Yes,
That is why, I take a look now 53. My brother filed, this is a recent 28th of July 2025. File a RTI report, page 53 and accept 21.
Mhm.
This is
Page 53.
my lord.
What is this?
Maharashtra State Dental Council. When police running after me and I have been already arrested, my own brother file a RTI. That is why RTI application is incident to this. Maharashtra Dental Council, it is a valid and bona fide registered with the Maharashtra State Dental Council. The registration number is genuine and duly recorded in the council office record. This is the RTI report. Under compulsion, my brother have to file. Because their purpose is to malign my prestige and book me behind the bar.
क्या लिखा? Fake registration certificate. Stop. Learned counsel for the petitioner has submitted that the petitioner has done his bachelor BDS course from Kalka Dental College and Hospital and has also been registered
Under Maharashtra State Dental Council.
Registered under the provisions of Dentist Act 1948 under Maharashtra State Dental Council. Stop. Learned counsel for the petitioner submits that as per section 46 of the Dentist Act 1948, any dentist who has been registered in any of the state council may practice in any other state without there being any necessity of re-registration in the concerned state. Learned counsel for the petitioner has also submitted that the petitioner was arrested in connection with AC, in connection with Borpeta PS case number 151/2025, in which was registered on the basis of similar accusations made against the petitioner. However, a coordinate bench of this court, by its order dated
18/8.
18/8 2025 in bail application number 2658/2025 has allowed the petitioner to go on interim bail,
My lord.
interim bail in that case. The petitioner, learned counsel for the petitioner has also referred to an information sought by the brother of the petitioner under RTA Act from Maharashtra State Dental Council. Stop.
it-
Said information is annexed as annexure 21 to the instant bail application, wherein it has been informed that the present petitioner, namely Ziarat Hussain, bearing registration number A-50838, is a valid and bona fide registrant with Maharashtra State Dental Council, and the registration number A-50838 is genuine and duly recorded in council's officials record. Stop. On the other hand, learned additional public prosecutor submits that since in the FIR it has been stated that the Maharashtra State Dental Council in its letter dated 6/5/2024 has stated that the petitioner has fraudulently registered with Maharashtra State Dental Council through unauthorized access to the website. She prays for calling of the case diary. Stop. Let the case diary be called for. However, considering the submissions made by learned counsel for the petitioner as discussed in foregoing paragraph, as well as supporting documents annexed along with the bail application, the petitioner in the meanwhile is directed to appear before the investigating officer of Howli Police Station, case number 129/2024, and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with aforesaid case, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority, with following conditions. Stop. Let this case be listed again on 17/9.
48. Hello. May I criminal instead of 17 and 1991.
Okay, 19/9.
19.
Abhishek 19.
19. Hello.
May it please your lordship. Madam, POCSO section 4, madam, regular bail application. Notice will go, madam. POCSO.
Heard Mr. S. Das, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor. It is pending investigation.
Pending investigation.
Let the case diary be called for and let notice be issued to respondent number 2. Stop. The petitioner shall take steps for issuance of notice upon respondent number 2 within 3 days from the date of this order, in pursuant to the prevailing notification of of the registry in this regard. Returnable on
4 or 5 days.
5th of September, list accordingly.
May it please, Your Lordship. Lordship, it's a very longish FIR, my lord. I'll just try to make it short, my lord. Page number 11 is the FIR. My lord, the petitioner before your lordship, the petitioner number 1 is a 73-year-old man, and the petitioner number 2 is a, my lord, is the daughter of petitioner number 1, who is a lady. Now, my lord, the FIR is at page number 11. The FIR, in fact, is lodged by some self-help groups alleging inter alia that, my lord, the accused number 1, because, my lord, there are as many as 10 accused persons. My lord, may kindly turn to page number 14. I'll just show the list of the names of the accused persons. My lord, is there at page 14?
Yes.
Now, there are as many as 10 accused persons, my lord. The allegation in short is that the accused number 1 had printed some fabricated money received in the name of those self-help group, and he has collected some money from the local people, and he has misappropriated those money. It is further stated in the FIR that the accused number 1 in a public meeting had admitted the fact that he has done all this thing, my lord, and that he alone is responsible for that. It is also there in the FIR, my lord, that this accused number 1 had in fact refunded an amount of 35 lakhs to this organizations, my lord. Be that as it may, my lord, I am not on the
Which self-help group?
These are, my lord, Jana Kalyan.
More than one.
More than one. Jana Kalyan, Nidhi, Shilpi, Aru,
Okay.
Bonit, these are the. So, my lord, the allegation is against accused number 1. My lord, I am not on the veracity of the allegations in the FIR. My lord, there are documents to suggest that there is a civil case pending between the accused number 1 and those self-help groups. In fact, I have annexed a copy of the plaint.
Okay.
Now, these people, say even except accused number 1.
Who are the petitioner in this case?
My lord, the petitioners happen
How many petitioners are?
Two petitioners.
Number?
That
3
is
and 10, Lord.
accused number 3 and 10 if I go by the FIR. There is no specific act attributed to accused number 3 or for that matter accused number 10, save and except a sweeping remark that in connivance with the other accused. The entire allegation is squarely, if I may read some part of the FIR, if your lordship kindly come to page number 12, my lord.
Yes.
The 5th line from top. But when allegations were found, your lordship is there?
Yes.
But when allegations were found that the accused number 1, my lord will kindly take note of this, by means of forgery has printed books and other papers in the name of all these self-help groups, and also by forging signature of the secretary has illegally collected huge sum of money. Accordingly, a meeting was convened by those self-help groups, and the matter was thoroughly examined. During such inquiry, it is found that accused number 1 in connivance with 2, 3, and 4, as well as other accused persons. This is a sweeping comment. Had collected more than rupees 2.5 crore and misappropriated the same. In the meantime, my lord will kindly take note of this. In the meantime, the accused number 1 in various public meetings has clarified that no office bearer or members of the Jana Kalyan Nidhi such and such are not involved in such collection of money, and further confessed in the public meeting that he himself had collected the money and kept it with him. Therefore, on last 1/2/2025, the accused number 1, again accused number 1, in the presence of the office bearer members of such and such, had refunded 35 lakhs and the same was received. My lord, may I skip all this? These are again reiteration of the same thing. This is one. Now, my lord, the correctness of the allegation, I'm not on that. My lord will see there is a civil case at page number 21. This is the accused number 1. While the civil case
in respect of what matter?
in respect of this financial transaction, with a prayer, the prayer of the civil suit, your lordship will find the prayer at page number 35. This is against those informant organizations. A decree be passed for recovery of 35 lakhs because according to him, he was pressurized, blackmailed, and this 35 lakhs was taken. He had to give this 35 lakhs on account of some pressure and some, my lord, backhand tactics. So these are the prayers. My lord, I'm not on all these things. 73-year-old man, daughter, let them go and give their statements. CD may be called, let them go and give
We
their
are
statements.
disposing it off. Then.
Absolutely.
Mr.
Absolutely.
Heard Mr. M. Bishwas, learned counsel for the petitioner, also heard Ms. N. Das, learned additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioners, namely Vishnu Goswami and Jayashree Goswami, alias Jayashree Goswami, who are apprehending their arrest in connection with Sipajhar PS case number 104/2025 under section 120B/406/420/468 of the Indian Penal Code. The gist of accusation in this case is that on 11/7/2025, one Kulendro Deka and 3 others had filed an FIR before the officer in charge of Sipajhar police station, naming therein 10 numbers of accused persons, including the present petitioners. Stop. It has been stated, inter alia, in the said FIR that the accused number one, namely the FIR, namely Sri Ganesh Sharma, had printed, forged what books? Forged
Received books.
forged books and other papers in the name of Jana Kalyan Nidhi, Shilpa Aru Banijik Samabhay Samiti, Patharighar, and also forged the signatures of secretaries of the said NGOs and illegally collected huge sum of money. Stop. It is also stated in the FIR that the accused number one has done so in connivance with other accused persons. Stop. It is further stated in the FIR that in various public meetings, no, stop. I got line to Kiasi. Cut this line. Learned counsel for the petitioner, Mr. M. Bishwas, has submitted that on bare perusal of the FIR, it would reveal that the main allegation of misappropriating, main allegation of collecting and misappropriating money is leveled against the accused number one, Shri Ganesh Sharma. He further submits that in the FIR itself, it has been stated that in various public meetings, the accused number one has clarified that no office members of any NGO are involved in such collection of money, and he himself is responsible for the same. It is also submitted by learned counsel for the petitioner that on 1/2/2025, the accused number 1 had refunded rupees 35 lakhs to the informant number 2, Shri Bhavendra Sharma. Stop. Learned counsel for the petitioner has submitted that the petitioners are in no way involved in the offence alleged in the FIR, and he also submits that the petitioner number 1 is a aged person of 73 years of age, and petitioner number 2 is a lady, and they are ready to cooperate in the investigation. He further submits that there appears to be a dispute between accused number 1 named in the FIR and the NGOs involved, as apparent from the fact that the accused number 1 has also filed a title suit against this against the office bearers of the said NGO, namely Jalakalyan Nidhi, for realization of the amount of rupees 35 lakhs which was paid by him to the said NGOs and for other reliefs. Stop. Learned counsel for the petitioner has also submitted that since the petitioners are ready to cooperate in the investigation, their custodial interrogation may not be necessary. Hence, he prays for allowing the petitioners to go on anticipatory bail. On the other hand, learned additional public prosecutor prays for calling the case diary. Stop. I have considered the submissions made by learned counsel for both the sides. From the submissions made by learned counsel for the petitioners as well as on perusal of the FIR, it appears that main accusation in the said FIR is against the accused number 1, namely Ganesh Sharma. It also appears that said Ganesh Chandra Sharma has also filed a civil suit bearing title suit number 77/2025, which fortifies the submissions made by learned counsel for the petitioner that the main dispute is in between Shri Ganesh Chandra Sharma and the office bearer of Jalakalyan Nidhi. And the other NGO named the Shilpa Aru Banijik Samabaya Samiti Patharihat. In view of the aforesaid facts, this court is of considered opinion that if both the petitioners cooperate in the investigation, their custodial interrogation may not be necessary for fair completion of the investigation of Sripajhat PS case number 104/2025. In view of above, Both the above named petitioners are directed to appear before the investigating officer of Sipajhar PS case number 104/2025 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If they do so within the stipulated period, in the event of their arrest, they shall be allowed to go on bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of the arresting authority. This with following conditions. This anticipatory bail application is accordingly disposed.
I'm deeply obliged.
That clearest application, Lordship, kindly have a look at page 16 is the FIR, Lordship.
Page 15.
Lordship, it started from 13, Lordship, and party person.
Page 16.
16, my lord.
16. Yes.
I'm married. I have the honor to report that today, 2/3/2000 at about 12:20 AM, on being received an information by the OC Dolai PS from patrolling staff such and such of Dolai PS, and one vehicle bearing registration number plate was suspected, and when it was signaled by them to intercept for search, then the driver of the vehicle moved forward and stopped the vehicle by the edge of the road at Chodgram National Highway 306 and managed to flee away by leaving the vehicle, which made them to believe that there might have suspected articles and the reason why the driver left it when signaled. Accordingly, the patrolling staff reported the same to the OC Dolai PS. Being received the information, OC Dolai PS has consulted the same with the Honorable SP Kachar, and police team was constituted under the leadership of the OC Dolai PS as follows to conduct the operation. Team of the Dolai PS, police constable such and such. Accordingly, I along with the above police team under the leadership of the OC Dolai PS, along with available NDPS kit have taken depot from Dolai PS at 12:30 PM with the departmental MD and proceed towards the Shodram National Highway 306 and reached there at 12:55 PM. After reaching Shodram, we found the patrolling staff guarding the vehicle. The police team started conducting search for the escaped driver. So, Lordship, in this case, there is a recovery of 183 grams of heroin, suspected heroin, and the driver managed to flee.
Who are you?
I am the owner of the vehicle. Lordship, now your Lordship kindly come to page.
What vehicle is this?
Lordship, it is a Bolero, Lordship.
Bolero.
Pickup.
Lordship. Lordship, kindly come to charge sheet, Lordship.
This is a charge sheeted case.
Lordship, kindly.
Then why anticipatory bail?
It is submitted under section 22B,
B.
Lordship. B.
There is no bar in granting bail to you by the trial court.
Lordship, but.
You have received summons.
Lordship.
You have received summons.
Lordship,
Appear before the trial court.
I will appear, but I'm Lordship may protect Lordship similar in some other cases, but I may be protected. I'm only on suspicion. Lordship, kindly have a look at page 23. Charge sheet, Lordship. Why against me charge sheet was submitted only on suspicion, Lordship. Police stated in the charge sheet, Lordship. Page 23. Interim protection may be granted. I will appear before the court. I am ready to face the trial only on suspicion. Charge sheet filed against me, Lordship. Why I was not.
No, you satisfy this to the trial court.
But similar relief may Lordship may grant Lordship. Otherwise, I will be arrested, Lordship. For no fault, I'm no way.
Why are you? If you have a good case, you can satisfy the trial court. Trial court has not issued any coercive process. It has issued only summons.
It is true, but
so issuing summons indicate that it does not have intention to keep you behind the bars if you have a good case.
So what, it is NDPS case, Lordship. They have
But
filed-
there is no
filed-
embargo.
That is,
37,
But
I am
because-
disposing of it, directing you to go to the trial court, trial,
may be granted till
no relief
inter-
from this court.
Interim,
Interim, why you require interim? There is no, on the strength of summons, you will not be arrested. Where is the apprehension?
Lordship may observe that aspect, Lordship. He may not be arrested, Lordship. That aspect may.
It is, without a warrant,
Other-
if
otherwise,
NDPS NBW will issue, then it will be arrested, otherwise, how in?
Lordship may observe that aspect.
Mr. L.R. Majumdar, learned counsel for the petitioner, also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioner Rohimuddin Laskar, who is apprehending his arrest in connection with. What is the case number?
Lordship, it is,
NDPS case number 59/2025, pending before the Court of London. Session Judge Kachar,
Session comes special judge, my lord.
Sessions come Special Judge Kachar. The gist of accusation in this case is that on 2/3/2025, one Shyamali Gogoi, SI of police had lodged an FIR before the officer in charge of Dholai police station, inter alia, alleging that during regular Naka checking duty, one Bolero pickup van bearing registration number AS 11EC6615 was intercepted. However, on seeing the police, the driver, leaving the vehicle on the road, fled away therefrom. Stop. On this, due to suspicion, the said vehicle was searched by the police, and during search operation, 183 grams of suspected heroines was recovered from the said vehicle. The said heroin were kept in the soap boxes. Stop. Learned counsel for the petitioner has submitted that after completion of the investigation, charge sheet has been laid showing the present petitioner as, how many accused are there?
Two, Lordship, driver and deputy.
Showing the present petitioner
As absconder, my lord.
as absconder in the charge sheet.
Lordship, kindly have a look at page 23. Once it is
20?
clearly stated in the
23,
page 23, Lordship,
17.
drivers did register owner never approached before me to provide the driver's detail or to take the vehicles in his Jimma rather than continue absconding. So that's why against him charge sheet is laid.
Charge sheet along with one another co-accused, who is the driver of the said case, said vehicle. Learned counsel for the petitioner has submitted that the petitioner is in no way involved in the offence alleged in the FIR, as he was unaware about the fact that his vehicle has been used by the driver for carrying the seized contraband. He also submits that now the trial court has issued summons to the petitioner fixing 21/8/2025 This date has lapsed. 21, what is the next date?
Next date of instruction.
No, you should have,
I will appear within 15 days, Lordship, or within next date.
no, date is available in the website. You should have seen, inquired. 21/8/2025 for his appearance. However, the petitioner apprehends that as he has been shown as absconder in the charge sheet, he may be detained behind the bars if he appears before the trial court in pursuant to the summons issued by it. Stop. On the other hand, learned additional public prosecutor Mr. K.K. Parashar has submitted that in this case, there is no apprehension of
Especially disabled girl has been sexually assaulted, Lordship. So there is no tenable ground for him to be.
May it please the Lordship. Lordship is the NDPS intermediate quantity Lordship. On the strength of the NBW, I was arrested on 28th of August 2024. And that is 365 days till today. And my co-accused Samiran Beva has already been acquitted, Lordship.
Acquitted.
Yes, Lordship.
Trial,
His trial is going,
the
going on.
record was split up.
Yes, Lordship.
Also, there is an office note, I'm sorry.
What is the stage of the trial now?
Co-accused has been acquitted, but
The records have not yet arrived. We have to wait. Records, I say. Young Jokson. Mr. Sharma, please go through. What is the status? How much is the contraband?
15 kg ganja.
1.5.
1.5. But I was granted bail then due to COVID-19 and some personal problem.
You were on bail.
Yes, Lordship.
Then
Then due to NBW, I was arrested.
Okay. When you were arrested?
In 28th of August 2024, and today is 27th of August. It's 365 days, Lordship. 1 year.
And what is the stage of trial now against you?
Trial is going on in the evidence stage.
How many witnesses? The witnesses are again called, or you are only cross-examining?
I have not. Yeah.
What is the status of trial?
Statement has also been recorded.
Of the But for 15 kg, 365 days is a long detention period.
Yes.
What is the assurance that if you are allowed to go on bail, you will cooperate in the trial?
Grant the local bail. Local bail.
Where do you stay?
I am from West Bengal.
Oh, West Bengal.
Local surety make me up.
No, let him go through. What is the status? We'll take it up after some time. At what stage the trial is pending? Yes, Mr. Dutt.
My lord, here, my lord, 47 and 48 notice, my lord. It's not available, I think.
These are the only ground.
Yes, my lord, in the TCR, my lord, Lordship may peruse page 38, my lord. Only a WT message has been sent, my lord.
It will record the.
Serial page number, my lord, 37, that is the notice under section 47, my lord. And page 38 is the.
No, it says suspected Yaba tablets were seized and recovered from your possession.
Yes, my lord.
Next page, Lordship.
Next page, my lord.
48.
Page 38. Page 38,
You find a WT message.
Yes. What is this?
This is the WT message, Lordship. Since you from outstation, Lordship, the WT message was sent to the concerned police station to inform his family members. That is the issue here, Lordship.
we have not received, my lord.
What is your submission?
Your Lordship, in view of the recent judgment, Lordship, they have to show the prejudice that has been posed to them, Lordship. In the absence of, whether if in the absence of 47, that could have been a ground, Lordship, but now since 47 was issued and he was arrested on 3/11/24, on the next day, Lordship, when he was produced, the magistrate Lordship will kindly see 4/11/24. Order dated 4/11/24, Lordship will kindly see, I have flag mark.
My friend is submitting on that Darshan's case, my lord. Now, the question is, my lord, there are bench strength is 2, my lord. Whether this present case will be applicable in the case or whether the judge of a high court will follow the latest one or the earlier one. That is the question. If my friend can satisfy to that, my lord. But recently, my lord, last 21/8, my lord, I got a bail in a NIA case, NIA. The Union of India came to this court, my lord, on appeal to cancel my bail, my lord. Now, my lord, that it's a division bench order, my lord. Now, lordship may directly go to paragraph 15, 1(5).
Yes,
Paragraph 15, my lord. May I read?
yes.
In Sri Darshan Supra, the Supreme Court has negated the submission of the learned counsel for the accused respondent that an arrest would be illegal if the grounds of arrest were not furnished immediately, thereby violating Article 22(1) of the Constitution of India. Now, Section 47 of the BNRL. However, in case of Vihan Kumar, the decision of the Supreme Court therein is to the effect that the grounds of arrest has to be writing and has to be furnished to the relatives of the arrested person. Thus, there appears to be dichotomy of views in the different decision of the Supreme Court. However, keeping in view of the judgment of the Constitution Bench of the Supreme Court in the National Insurance Company versus Pranay Sethi reported in so-and-so, wherein it was held, if there was a conflicting decision of equal bench of the Supreme Court, the earlier decision should be followed by the High Court. We are bound to follow the earlier decision of the Supreme Court, which in this case would be Vihan Kumar.
Okay, that is settled by
That
the
is settled
division.
law, my lord. This is a 5-man constitutional judgment, my lord. That Pranay Shetty. So now the division bench have held, my lord.
The question of prejudice will not come. The Sri Darshan's case will not rescue the prosecution.
That is the law, my lord.
You have to find out whether notice was given. Though there is a WT message.
Apart from them, nothing is there. That is true.
And in the, my lord, that case, my lord, the division bench case, my lord, where I argued, my lord, there, my lord, a copy was sent to the relative and it was signed, my lord, but no date was given, my lord.
Oh, what is there in the WT message? Read the WT message. It only a request has been made to intimate the family members regarding fact of his arrest.
Yes.
Not the grounds. Heard. Mr. N.J. Datta, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Mizanur Rahman, who has been detained behind the bars since 3/11/2024 in connection with NDPS case number 127/2025 under section 22C of the NDPS Act 1985. The gist of accusation in this case is that on 3/11/2024, one Anwar Hussain Sheikh had lodged an FIR before the officer in charge of GRPS Guwahati, inter alia, alleging that during regular train checking duty, the police team, regular train checking duty, the police team while conducting checking in train number 15626 DN Deoghar Weekly Express at platform number 1 of Guwahati railway station. Recovered. What was recovered?
My lord, 1020 grams of my lord Yaba tablet.
1020 grams of Yaba tablet. Stop. From the possession of the present petitioner.
Yes, my lord.
Present petitioner. Learned counsel for the petitioner has submitted that the petitioner is seeking bail in this case mainly on the ground that no written grounds of arrest were communicated to him at the time of his arrest, as well as no notice under section 48 of the BNSS was served on the relatives of the petitioner as after his arrest. He submits that it is apparent from the record that only a WT message was sent to the officer in charge of Sonamura PS police station to intimate the family member of the petitioner regarding the fact of his arrest. However, no grounds of arrest were mentioned there in the said WT message. He also submits that there is also no record as to whether in fact even the fact of arrest was communicated to the family members of the petitioner in pursuant to the said WT message or not. He therefore submits that there has been a violation of Vihan Kumar Diakson.
2025 SCC online Supreme Court 269.
There has been a violation of the guidelines laid down by the apex court in this case, in case of Vihan Kumar versus State of Haryana and another, reported in 2025 5 SCC 799. On the other hand, learned additional public prosecutor has submitted that the notice which was served on the petitioner under section 47 of the BNSS after his arrest do mention that he was arrested for carrying Yaba tablets, which was seized in this case. And therefore, he submits that grounds of arrest have been stated in the said notice. However, he fairly submits that as regards notice under section 48 is concerned, there is only one WT message available in the records, which indicates that the said WT message was sent to the SHO, officer in charge of Sonarmura police station, for intimating to the family members of the petitioners regarding the fact of arrest of the petitioner in connection with GRPS case number 229/2024. However, in the said WT message, nothing more which constituted the reasons, which constituted the basic facts necessitating his arrest have not been mentioned. He also fairly submits that it also cannot be said from the materials on record whether in fact in pursuant to the said WT message, anything was informed to the family members of the petitioner. He, however, submits that in the apex court in the case of state of Karnataka versus Shri Darshan, etc., within bracket criminal appeal number 3528/353334 of 2025, has observed that mere absence of written grounds ipso facto does not render the arrest illegal unless there is a demonstrable prejudice or denial of fair opportunity is shown by the said petitioner. Stop. To counter in response to this submission of the learned additional public prosecutor, learned counsel for the petitioner has produced a judgment of a division bench of this court in the case of National Investigation Agency versus Hang Min Len Mate, THANGMINLEN, Asylum, Mate. Within bracket criminal, or within bracket order dated 21/8/2025 in criminal appeal number 234/2025, wherein the division bench has, after giving reasons and after relying on the observations made by the apex court in the case of National Insurance Company Limited versus Pranay Sethi, reported in 2017, 16 SCC 680, had held that the decision of the apex court in case of Vihan Kumar within bracket Supra, which is prior to that of decision, prior to that of Sri Darshan Supra, will be applicable, and the grounds of arrest in writing would have to be made known not only to the arrested person, but also to the family members / relatives / nominated person of the accused person, arrested person. I have considered the submissions made by learned counsel for both sides. In this case, apparently, there is nothing apart from the WT message dated 4/11/2024, on record, to show that the grounds of arrest were made known to the family members / friends / nominated person of the arrested person, nominated person of the petitioner in this case. Hence, there has been hence, in view of the observation made by the apex court in the case of Vihan Kumar Supra, this court is of considered opinion that by not furnishing the grounds of arrest in writing to the family members / friends / nominated person of the petitioner, there has been a violation of the fundamental rights of the petitioner guaranteed to him under Article 22(1) of the Constitution of India, as well as there is also violation of the provisions of Section 48 of the BNSS. And as per the observation made in Vihan Kumar Supra, such a violation would render the arrest of the petitioner illegal. And he would be entitled to get bail on that count only. Stop. For aforesaid reasons, the petitioner is allowed to go on bail of how much is the contraband?
2050 grams of yaba tablet.
Of 50,000 with one surety of like amount, to the satisfaction of the trial court with following conditions. Trial conditions. This bail application is accordingly disposed.
I'm of that. Deeply.
My lord. My lord, may I kindly take this. My lord.
Into chamber of the.
My lord, this half page is my case, my lord.
Your Lordship, the IO was out for operational duty. That's why we did not receive the objection. Your Lordship may grant us short period of time so that we can
My
file
lord,
the objection.
this notice in this case was issued in the month of July, 22 July, more than 30 days, my lord. My lord, LCR is before the court, my lord. My grounds which I am alleging are, my lord, even they file a thesis on this subject that they cannot supplant that by means of an affidavit.
But they are entitled to file.
My lord, they are entitled, they were given time. This case was supposed to be listed on 11/8. 11/8, your lordship may see this, the order sheet of this case. It was supposed to be listed on 11/8. It did not got listed in 11/8.
How much time you will require?
Short period of time. Actually, by next week. We'll
my lord, what they do is that, my lord, she has been just within 5 minutes back, she was handed over this file.
No,
These things, my lord,
we are giving a short date.
bad habits die hard, they say, but my lord, Lord, after 1 month also they take time. My lord.
Today is the second date actually.
I don't-
Heard Mr. M. Bishwas. How much contraband is involved?
My lord, contraband was recovered in the year 2021. He was arrested in the year 2024.
707 kg of ganja, Your Lordship.
Okay, let them, I'm giving one chance. Heard Mr. M. Bishwas, learned counsel for the petitioner. Also heard Miss, what is the name? R. Hussain, learned counsel for NCB, who prays for a short date to enable the NCB to file written objection. In this case, she submits that the NCB was not able to file written objection as the concerned investigating officer is engaged in operational duties.
For last 30 days, my lord. That may be recorded because her submission is for last 30 days. Because the notice was issued on 22/7/2025.
Stop. Considering the submissions made by learned counsel. No, stop.
Friday, my lord.
Learned counsel. The one chance is granted to the petitioner to file written, the NCB to file written
My lord,
objection.
3 days back, we called them. Because the cause list was out, my lord, we
when will
called
you
them
file?
Your
telephonically.
Lordship, Your Lordship may fix it on 2nd of September.
On 2nd of September.
2nd of September, there is a BC in Mizoram. No? 1 first, let it be on 1st of September, my lord.
On 1st of September.
My lord, no further chance would be given to my lord. Kindly observe no adjournment on this ground, my lord.
No observation.
Because, my lord, nowadays I take an additional pain against the NCB. I call them that your matter is listed such and such, kindly file it. Now, only thing left is to give a written invitation or what sort of, my lord, request.
You may do so also.
But nothing is yielding, my lord. Same old thing.
Yes.
Mayor, please, Lordship, whether CD was called from,
He did not receive, Lord.
it is 43 days, my lord. It is
What is the offense?
13.949 kg of ganja was recovered, my lord.
From Gochu, Lord.
So it is the third day, my lord.
Wow. How many days you are behind the bars?
Today is 43 days, my lord, including the date of remand, my lord. I was arrested on 16/7/2025. The
Why you
contraband
are,
was recovered.
why? Okay. On. Heard Mr. N. Mahajan, learned counsel for the petitioner. Also heard Miss N. Das, learned additional public prosecutor, who seeks one more chance to produce the case diary. The prayer is allowed. Let this matter be listed on 1st of September.
After when I was carrying on my handle, man, I thought, as per instruction, that he was carrying it because he thought it was tea leaves, man. He was about to receive 2,000 rupees for the delivery, man. On both things.
Okay, we'll see.
Like,
I hope, my lord, this case at least they don't take any adjournment.
NCB.
My lord, NCB, my lord, item is called cause list was published since 2 days back. I am appearing, my lord. I do not know about that.
Yeah.
DRI, the same set of, but this is my case, my lord. My lord, may kindly see this piece of paper, my lord. This is my case.
Trial court records have come.
Yes, yes, yes. This is my case. I hope this time she'll make some submission on
No,
that.
Your Lordship may kindly pass over this matter for the time being. Mr. Kial is on notes.
Okay, let him come.
He will appear, Your Lordship.
Okay.
At what time, madam?
We will take it after lunch.
At 2.
Not at 2, after lunch.
My lord, this matter may be taken up after some time.
After lunch.
Oblige.
Charge is submitted, Lordship.
What is your name?
Call for.
Charge is submitted.
What is your name?
I say.
Heard Mr. I. Hussain, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid bearing charge sheet number. What is the charge sheet number?
Lordship, charge sheet number 525/25, dated 24/7/25.
Stop. In view of the fact that the charge sheet has already been laid in this case, this bail application is disposed of with the observation that the petitioner may approach the trial court and may pray for regular bail before the said court, if so advised.
24. May I please have nothing?
City is the Lordship.
My lord, kindly please have 2 p.m. my lord.
2 p.m. on matter is 50.
On behalf of SCO, he is on legs, my lord.
Yeah, after some time.
25.
May I please?
Charge is submitted.
That is petitioner is behind the bars since my lord 60,025 money. Your lord- And special judge already rejected his bail petition matter. So your lordship may at this stage call for the LCR matter. Even your lordship may found it order dated 12/2025 method. He is just a extrapolar method and who just transported the 2 cylinders to the house of the accused method. By that time, police have arrested him along with the accused person. From whom the contraband has been
Heard Mr. T. Sheikh
I alone.
I. Alam, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid bearing charge sheet number
611/25, dated 21/08/25.
Stop. Learned counsel for the petitioner has submitted that since there is an embargo under section 37 of the NDPS Act, even after laying of the charge sheet, it would be futile to pray for bail before the trial court. Hence, he prays for a calling of the scanned copy of the records of the trial court. Stop. Considering the submissions made by counsel for the petitioner, let the scanned copy of the records of the trial court be called for fixing 17/9.
My lord. Oblige.
May I please, my lord?
Yes.
I shall not repeat the affair, my lord, because yesterday I have read. But basic allegation is that an NOC was forged by accused number 1, and by forging that particular NOC, a plot of land has been sold to me. And in that particular affair, my lord will find that there is no particular victim in this. Because the person who has lost this affair, his plea was that he has initially obtained that particular NOC, and after obtaining that NOC, he has sold his land to one relief party. This is the very basic allegation. Now, my lord, point here to be noted is that this is an affair that has been delayed by more than 2.5 years. Because NOC was dated, my lord,
No, but how to overcome the earlier order? There is an earlier order of rejection.
Earlier order of my lord rejection. Yes.
Rejection,
Yes.
where some reasons were mentioned for rejecting your prayer.
Yes.
You have to overcome that.
Yes. No,
Yes, how to overcome?
yes, my lord. For the purpose of new ground, my lord, I have already annexed a particular document that the present petitioner is suffering from heart disease.
Heart,
Heart disease.
but
And he was diagnosed in Populi Hospital Research Center at page 60. That is point number 1. And there are some legal aspects that has been not brought to the notice of this honorable court,
what?
that no cognizable or bailable offense has been made out in this case. That is the second one, my lord. And the third one is there, my lord. There was a case where Bibha Bora himself is the witness to that particular case, where her own brother has been expired, own brother has been killed. That particular case has an indirect link to this particular case.
How?
How? My lord, one by one, let me come, my lord. Otherwise, the whole things get too complicated. Now, first, I would like to establish that the accused number 1, who happened to be the Bibha Bora, she is the legitimate owner of a particular plot of land which has been sold to accused number. That particular point, I want to substantiate by taking my lord.
Jamabandi copy.
Jamabandi copy.
That you have done.
That I have done, my lord. And there is a, my lord, specific order of the circle officer at page 49. At page 49. My lord, may kindly come to the next order.
Yes.
And all these I am putting from my lord, from an official website. It is integrated land record management system. It is available in the website, my lord. My lord, may kindly come to the second order. Sokro Bekhoyar, 15/9/2000 তারিখ. Have my lord found?
Yes.
Sokro Bekhoyar, 15/9/2000 তারিখৰ নামজারি নাম্বার so and so muted ধৰক হুকুম মতে 964 নং দাগৰ 2 কথা মাটি খৰিদাৰী সূত্ৰে নিৰুদ বৰাৰ লগত, নিৰুদ বৰা is the brother of বিভা বৰা, লগত শ্ৰী বিভা বৰা, লগত শ্ৰী অনিল ৰাজখোৱাৰ নামত নামজাৰি কৰা হ'ল. Registration deed number so and so. Another important aspect is that the Lat Mondal, who placed the report to the circle officer, his name is Ranjit Soitala. So, area of land measuring 2 kotha land has been purchased by 3 individuals, Nirud Bora, Bibha Bora, and Uli Raska. Thereafter, my lord, Bibha Bora has sold her share of land to Unil Raska. That order, my lord, will find at the next page, at page 50. This is the second order, my lord. At page 50. My lord, may kindly come.
Yes.
My lord, found it? The order?
Yes. Yes.
Here, my lord will find Sokro Bifai 27/2/2000 তারিখৰ নামজারি নং ইমান so and so হুকুম মৰ্মে 964 নং দাগৰ 1 কথা মাটি খৰিদাৰী সূত্ৰে বিভা বৰাৰ লগত অনিল ৰাজখোৱাৰ পিতৃ নুমল ৰাজখোৱাৰ নামত নামজাৰি কৰা হ'ল. Registration deed number 1019 of 2007. My lord. Now, this particular deed, I have also annexed that my lord will find at page 21.
This is the land which is mentioned in the FIR. Is this the land?
No, no land has been mentioned, my lord. Only NOC has been mentioned in the FIR, through which the land has been sold by.
Sold. Which land has been sold? This land.
This particular land has been sold.
Second order.
Yes, ma'am. By the second order. And
Now-
I have also annexed the registered sale deed, my lord. That is at page 21. But for now, I am not taking. Now, my lord, this is a case that has been registered under 4 sections. 120B, 420, 468, 471. One thing is certain, your honor, the land that has been sold by the accused number 1, that particular land belongs to her only. And she has every right to alienate her property, my lord. Keeping this in view, my lord,
What 420 section says? Whoever being deceived by fraudulent and dishonest manner induce any person to transfer his property to some other person. That is not there, my lord, in this case. The ingredients of 420 has not been satisfied. Certainly. Thereafter, my lord may come to 468. 468 stands for, my lord, forgery for the purpose of cheating. Now, once that cheating has not been made out, nobody has been wrongfully alienated from his property. So 468, that is forgery for the purpose of cheating, has also not been made out. Now, the remaining section is, my lord, 471. Using forged document as genuine one. But this is a, my lord, bailable offense. This is not non-bailable offense. And my lord, regarding so far as the 120B is concerned, my learned friend on behalf of the state would better tell whether the agreement has been established between accused number 1 and accused number 2. And whether is there any my part on the overact in committing forgery to the NOC that has been alleged to have been false. Now, my lord, a particular submission has been made, my lord, that my wife, who happened to be the Sonali Bora, was also involved in some kind of land rejection. My lord, Sonali Bora, my lord, may kindly come to page 55.
Yes.
She is a school teacher, my lord. She is presently working at Kamrup Kameshwar Borthakur MV school. And she is still working in that particular school, my lord. But she has not been arrested. Now, my lord, suddenly, this particular city is flooded with material, not only against me, but against my entire family, my lord. And I'm absolutely uncertain, my lord, whether there is any specific material in regard to the allegation that has been made in the FIR. But there are several material in the particular city relating to the property against which, my lord, no FIR has been lodged. There is no informant, no allegation has been made. I have not been made accused.
Now there was an observation in the earlier order.
Yes, my lord.
That you misuse your liberty.
My lord,
What
I
is
never
your
misused my
submission on
liberty.
that?
For that, my lord, I would like to take, my lord, to my additional affidavit. Here, my lord, I do not have a positive case in my favor, but there is an implied inference that we have been treated.
You have been
We have been treated
threatened.
by the informant and some other people. My lord, may kindly come first to page 70, my lord.
1770.
No, my lord, 70.
Where is the additional affidavit?
Additional affidavit is there in the record, my lord. Last time, probably, I found it on the record.
No, additional affidavit থাকলে flag করে দিব। Page number?
My lord, page number 70.
Yes.
And the affidavit starts from, my lord, page. My lord, it ends at page 70, my lord.
Yes, what do
This
you
is
want?
connected to some other case, my lord. My lord, may kindly see the brief facts of the case. The brief history, the case is that on 26/4/2020, the complainant, Sri Nirod Bora, son of so-and-so, Major PS Kanpur, District Nagaon, lodged an FIR to the effect that on 25/4/2023 at 1:30 p.m., complainant went to Kamrup Circle Office to meet with one Lat Mondol Ranjit Hazarika, my lord, in the earlier order who passed the mutation order. And during discussion about his land dispute, in the meantime, accused Sri Jugal Rajbanshi came to the circle office and used slang language to him and punched his chest. As a result, he sustained injury on his person and he shifted to the hospital for treatment. Hence, a case has been registered, height, Kamrup PSK so-and-so. And my lord, the second line is very important. During the treatment of the complainant, Nirud Borwa was expired at Metro Hospital, Guwahati, and the dead body was sent to the Medical College Hospital, Bhangagar, for post-mortem examination by the Bokisa Police Station.
Now, who is this Jugal Rajbanshi?
No, Jugal Rajbanshi is the accused in this particular case. Here in this case, my lord, Bibha Bora is the star witness. That, my lord, will find at page 68. My lord, there is an implied inference that we have been trained so that accused of this particular case could derive a diluted testimony in this particular case so that he could get the
But
benefit.
Jugal Rajbanshi has not lost the affair.
Well, Jugal Rajbanshi has not lost the affair, my lord, but this particular case where I have preferred my bail application is impliedly connected with this case, my lord.
How?
Because this is particular affair that is against Bibha Bora, not against Anil Rajput. If my lord go to the
No, but
content of this
the
particular affair,
informant who lost the affair
my lord,
must have some link with
my lord, it is
Jugal
impossible
Rajbanshi.
for me to-
Only then some inference can be drawn.
No, my lord, that I totally understand, but I cannot produce some positive evidence which directly establishes a link. But my lord, there is sufficient material to infer my submission. Because this is an affair basically lost against Bibha Bora, and she has been arrested. Subsequently, she was granted bail by the Honorable Session Court.
Okay. Yes.
But at the same time, my lord, whether CD has any positive evidence, material, that I have some overt act in doing forgery to that particular NOC, my lord.
Yes, Ms. Das.
Lordship, otherwise sufficient materials are there, Lordship, and Lordship, Anil Rajput, Lordship, I want to point out this thing only that Anil Rajput, after getting liberty, he approached the informant and put pressure to withdraw the complaint. Complainant verbally informed the PS, and in this regard, a general entry has been made, Kamrup PS GDA number so-and-so, Lordship.
You give me the case diary. I'll go through the case diary and pass order day after tomorrow. Heard Mr. B. Deka, learned counsel for the petitioner. Also heard Ms. M. Das, learned additional public prosecutor. Let this matter be listed for delivery of orders on 29/8/2020.
Deeply obliged, my lord.
Make please allow. The conviction again under section 365 minutes for 1 year. Judgment your lordship will find.
You are on bail.
But 1 month was given, but that has lapsed. Friday is the date, my lord. We have informed that the appeal has been filed and it could not be taken up due to paucity of time. So therefore, we made a mention yesterday, my lord, for taking up today.
No, you were allowed to remain on previous bail by the trial.
Yes, by till 18/8.
Okay. Mr.
Because
B. Kaushik, learned counsel for the appellant. Also heard Mr. B. Sharma, learned additional public prosecutor. This appeal under section 415 within bracket 2 of BNSS has been filed by the appellants Nasiruddin Sheikh and Sahera PB, impugning the judgment dated 18/7/2025, passed in sessions case number 233/2018 by the Court of Learned Additional Session Judge Dhubri, whereby the appellants were convicted under section 365 of the Indian Penal Code and were sentenced to undergo rigorous imprisonment for 1 year, along with a fine of ₹1,000 each, with default stipulation in default of payment of fine.
One month.
With default stipulations, stop. Issue notice to the respondents. Since Mr. B. Sharma has appeared for the state respondent, number one, no formal notice need to be sent to the said respondent. However, as regards respondent number two is concerned, the petitioner shall take steps for issuance of notice upon the said respondent by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 3 months, returnable after 4 weeks. This appeal is admitted for hearing. Let the records of the sessions case number 233/2018 be called for the registry to take steps for requisitioning the aforesaid records. Any interim prayer
Yes,
is there?
Interlocutory application is there
Separate
for suspension.
list accordingly. This interlocutory application has been filed by the applicants, namely Nasiruddin Sheikh and Sahira Begum, in connection with criminal appeal number 327/2025. So this application has been filed under section 430 of BNSS, praying for suspension of the execution of sentence imposed on the applicants/appellants by the judgment dated 18/7/2025, passed in sessions case number 233/2018, whereby by the learned additional session judge Dhubri, by the impugned judgment, the petitioners, the applicants were convicted under section 365 of the Indian Penal Code and were sentenced to undergo simple imprisonment for 1 year and to pay a fine of rupees 1,000 each with default stipulation. Learned counsel for the petitioner has submitted that at the time of delivering the impugned judgment, the trial court had allowed to, where is that order?
Page 10. Page 10 in the bottom.
Allowed a month's time for filing the present appeal and also allowed the present applicants to remain on previous bail. The petitioner submits that, learned counsel for the petitioner submits that as the duration of the sentence imposed is a short duration of 1 year. Hence, unless the execution of sentence is imposed, is suspended during the pendency of the present appeal, during the pendency of the connected appeal, the purpose of filing the appeal would become infructuous if same is allowed to run parallelly. Stop. Any objection? Stop. Considering the fact that the sentence imposed on the applicants by the impugned judgment is only of 1 year, and also considering the fact that the connected criminal appeal number 327/2025 has already been admitted for hearing, comma, the execution of sentence imposed on the present applicants by the impugned judgment shall remain stayed during the pendency of the connected criminal appeal number 327/2025. The appellants are also allowed to remain on previous bail granted to them by the trial court during this period. This interlocutory application is accordingly disposed of.
Grateful.
May I please, Your Lordship? Here in this case, Lordship, this FIR is at page number 10. In this particular FIR, the allegation is that the petitioner along with some other persons entered into the residential house of the informant, and there was some assault on the part of the petitioner accused person's, Lordship. Now, when the case has been registered, Lordship, this is registered under section 351(2), 352, 353, 356, and 324. These are all bailable sections, Lordship, and only 353(3). This is non-bailable. I'm just referring to 353(3), Lordship, of the BNSS. 353(3) pertains to whoever commits an offense specified in subsection 2 in any place of worship or in any assembly engaged in the performance of religious worship or religious ceremonies shall be punished with imprisonment which may extend to 5 years and shall also be liable to fine. Now it is with regard to 353(2). Now 353(2) is whoever makes, publishes, or circulates any statement or report containing any false information, rumor, or alarming news, including through electronic means, with intent to create or promote, or which is likely to create or promote on grounds of religion, race, place of birth, residence, language, caste, community, or any other ground whatsoever, feeling of enmity, hatred, or ill will. So this particular section is no way attracted if we go by the contents of the FIR, Lordship. The annexure 1 is the FIR, Lordship. It's a translated copy. If we go by the contents of the FIR, it no way correlates with that particular 353(3). So on that view of the matter, Lordship, one of the accused person approached the learned trial court when he was arrested, and he was released on bail, taking into account the fact that the 353(3) is no way attractive. So
yes.
So prima facie, there is no material because other sections are all bailable and 353(3) is not attracted so far as the contents of the FIR is concerned. So in that view of the matter, Lordship may take note of the contents of the FIR and the relevant provision.
Yes, Mr. Sharma.
So this is AB, Lordship, whether they have appeared the court below, Lordship, that is not clear, Lordship. Otherwise, Lordship,
Let him appear.
Lordship,
Heard Mr. S.P. Chaudhary, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioner Rahul Das, who is apprehending his arrest in connection with Jalukbari PS case number 359/2025 under section 351 within bracket 2/352/353 within bracket 3/356/324 within bracket 2/115 within bracket 2 of BNS 2023. The gist of accusation in this case is that on 15/8/2025, one Baru Chetri had lodged an FIR before the officer in charge of Jalukbari police station, inter alia, alleging that the petitioner and along with one Mukesh Thapa were trying to consume liquor inside
Pani
the Pani Tanki And when the informant uh, ob-
Obstruct.
prevented them from doing so, they entered no, he failed to do so. Thereafter, the present petitioner along with the co-accused went to the house of the informant and entered into his house and assaulted his wife, assaulted the informant, his wife, as well as his minor son, and caused injury on his person. Learned counsel for the petitioner has submitted that in the meanwhile, the co-accused Mukesh Thapa was arrested and he has already been released on bail. This statement is right.
Konkon Pathak Lordship, it is at Annexure 3, page number 16.
Konkon Pathak was arrested and he has already been released on bail. Learned counsel for the petitioner also submits that all the offences under which this case has been registered, except offence under section 353 within bracket 3 of BNS, are bailable in nature. He submits that only offence under section 353 within bracket 3 is non-bailable. However, considering the facts alleged in the FIR, no offence under section 353 within bracket 3 is made out in this case. Stop. On the other hand, learned additional public prosecutor prays for calling of the case diary. Let the case diary be called for. Stop. In the meanwhile, as apparently it appears that the accusations leveled against the present petitioner in the FIR ex facie does not make out any offence under section 353 within bracket 3 of the BNS, 2023, he is the petitioner, namely Rahul Das is directed to appear before the investigating officer of Jalukbari PS case number 359/2025 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with the aforesaid case, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Number 1 and 2. List this matter on 19th of September.
Obliged Lordship.
Yes. You were once allowed to go on bail.
Yes.
Then you defaulted.
Yes.
Thereafter, no. After issuance of non-bailable warrant of arrest, you were.
I was arrested.
Yes, Mr.
The
Sharma.
year 2019, Lordship, the case was put up. Non-bailable warrant of arrest was issued, proclamation was issued. She did not.
No,
appear.
but now you stay in a different state,
Yes.
West Bengal.
Any
Wha-
stringent complaint
What
will
is
be
the
there.
assurance?
The local bailer may be
No, the experience is that even if local bailers are given,
Local bail or
it is very difficult. At what stage it is pending?
It's not clear, Lordship. The other ways, the records that is before your Lordship is in relation to the other co-accused who has already been acquitted, Lordship. Case was split up, Lordship. At the appearance stage in 2019, Lordship. Since 2019, she did not appear, Lordship. And Lordship, one more issue is that, Lordship, they had mentioned that earlier they had filed one bail application before the coordinate bench. They had given the number, but the copy was not annexed in the petition. I have been on same submission was made before the coordinate bench, it was rejected by the coordinate bench. Since 2019, they are responding.
No, but that bench is not available.
Yes, I understand the rules.
But on the strength of the length of detention, I may kindly be allowed to.
How the
This is intermediate.
presence may be ensured? You suggest, Mr. Sharma? Which government servant will offer?
From the state of
Assam
Assam.
government.
Heard Mr. M. Rahman, learned counsel for the petitioner. Also heard Ms. Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner, namely
Maleka Bibi.
Musammat Maleka Bibi, who has been detained behind the bars since 28/8/2024, within bracket for last 365 days in connection with sessions within bracket special case number 352/2011 under section 20B2B of NDPS Act, 1985, which is presently pending before the Court of Learned Special Judge, NDPS Kamrup Metro. The gist of accusation in this case is that the petitioner was facing trial before the Court of Learned Special Judge, NDPS Kamrup in special case number 352/2011 on the accusation of having possession of 15 kgs of ganja on 23/7/2011, which was recovered by the officials of GRPS during surveillance duty. Stop. Learned counsel for the petitioner has submitted that the charge sheet was filed after completion of the investigation against two accused persons. That is the present petitioner and one,
Samiram Deva.
what is the name?
Samiram Deva.
One Samiran Beva.
Acquitted.
She has been acquitted.
She has been acquitted.
Learned counsel for the petitioner has also submitted that the petitioner was earlier granted bail by the trial court. However, when you were granted bail? You have made a submission that you were on bail. You have not made any statement in the bail application to that effect.
I was in bail, but the date is not, like, the record is so volume.
Then you be ready. I'm keeping it part. And when you were granted bail, Abhishek Rogdo. Heard Mr. M. Rahman, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Let this case be listed for delivery of orders on 29/8, day after tomorrow. You give me that day.
Lord.
That when you were released on bail. Write it in a piece of paper and give it to court master.
Obliged.
My lord, when this matter was called in the morning, my lord, I handed over a piece of paper, my lord. In fact, these are my grounds on which I'm seeking bail primarily on prolonged incarceration, my lord. My lord, is there with that piece of paper, my lord, is there?
Yes,
Or that's my case, my lord.
yes, Ms. Dekka.
Lordship,
Not a single witness has been examined.
Three witnesses have been examined, two
Three witnesses. You have not mentioned in your paper.
PW3 is partly examined, Lordship. He was last examined on 10/4/25. It is there on record, Lordship.
Oh, my lord, it is written by hand.
It is kept blank.
My lord, that was given earlier, my lord, because thereafter the record was checked. It is two fully examined, one partly examined. Two fully examined, one partly examined. Dates. And the dates I can give, my lord. PW1 was examined on 22/11/2024, PW2 6/12/2024, and PW3 examination in chief 10/4/2025. Examination in chief, that too, my lord, not completely, partly examination in chief, PW3.
Yes.
He was arrested on 25/1/24, Lordship. And Lordship, here Lordship final complaint filed on 12/7/24. And Lordship charges frame on 2/9/24. And 23/9/24 was the first date of evidence, Lordship. In between, Lordship, witness came, Lordship. 4/11/24, two witnesses were present, but they could not be examined. In between, Lordship, witnesses came. So the Lordship, till now, Lordship, three witnesses have been.
You are from Manipur.
Yes, my lord.
What is the assurance that you will?
Lot of Manipuri people who are facing trial, my lord. Even I am, in fact, being engaged counsel for not less than 15 to 16.
Where trial is going on?
Metro, my lord. It
How
has ER connectivity, all connectivities are there.
Lordship, contraband recovered from him, both of them, Lordship.
How much?
How much was 1589.52 gram of Lordship heroin?
1589.
1,589.
It is a huge quantity.
At the end of the day, it is in terms
They
of
were
gram, my
caught
lord.
red-handed, Lordship.
No, my lord, whether red-handed or black-handed or blue-handed, that is trial will
But
decide.
quantities.
My lord, at the end of the day, my lord, quantity, my lord, whether how the accused will be connected, how they connect the accused with quantity.
Which case you are relying?
My lord, there are your lordship also, my lord, but these are the three cases, my lord, where the Supreme Court, after 1 year, 6 months, my lord, Supreme Court was of the opinion that that's the incarnation of more than 1.5 years was sufficient in case of NDPS, notwithstanding the mandate of section 37, because 21 will override 37 in case of prolonged incarceration. In fact, the lordship has also passed umpteen number of judgments. my lord.
Heard, Mr.
One judgment. Judgment of coordinate bench, Lordship. He was behind the bar for 4.5 years, Lordship. Bail was rejected, Lordship, on merit.
On what ground?
Delay was the ground, but on merit, bail was rejected, Lordship.
On merit, bail was rejected.
Contraband was recovered from him, Lordship.
My lord, in my understanding, this will not be a precedent for such cases, my lord. Because there are judgments of coordinate benches for 1 year, 6 months. And my lord, after this Vihan Kumar judgment, my lord, even 6 months, 3 months in commercial quantities, people got bail. In my submission, my lord, this will not work as a precedent for all cases, my lord. And we do not know the facts of that case as well, my lord.
Heard Mr. M. Vishwas, learned counsel for the petitioner. Also heard Ms. M. Deka, learned counsel for NCB. Counsel for DRI. This application under section 483 of BNSS has been filed by the petitioners, namely number 1 and number 2, who are detained behind the bars since
25/1/2024.
within bracket for more than 1 year, 7 months / 580 days. More than 1 year, 7 months, stop. The gist of accusation in this case is that on receipt of information through reliable sources, the to the effect that on 25/1/2024, 2 persons will be carrying huge quantity of contraband in a vehicle bearing registration number AS01DL 3273. 3273. A search team was constituted and the DRI official took lift in their vehicle.
About the gist of the accusation, your lordship will find at page number 3, para number 3, my lord. It is, they got an information that contraband would be carried in a XUV vehicle, my lord. Page 3, para 3 is the gist of the accusation.
What is the last word? Constituted and it intercepted the vehicle bearing registration number AS01DL3273 and a search was made in this said vehicle. During search, the present petitioners were found in the said vehicle and 115 numbers of soap cases were recovered therefrom containing suspected heroin. On weighing of the said heroin, it was found, the weight of this same was found to be 1589.52 grams. Stop. After completion of the investigation, the final complaint was lodged in this case on 24 on 12/7/2024. So learned counsel for the petitioner has submitted that the petitioners are seeking bail in this case mainly on the ground of prolonged incarceration. He submits that the apex court in several of its judgments have observed that prolonged incarceration overrides the embargo of Section 37 of the NDPS Act. He submits that though the petitioners are languishing behind the bars for more than 1 year, 7 months, however, till date, only 2 witnesses have been fully examined, and the third witness has been examining chief. Court para 9 from bail application number 3881/2023. He submits that the apex court in several cases where the offense involved is relating to commercial quantity of contraband under NDPS Act, and where the petitioners were detained behind the bars for more than 1 year, 6 months, have granted bail to such petitioners merely on the ground of prolonged incarceration. Stop. He therefore submits that the petitioners may also be granted bail on the ground that their fundamental right guaranteed to them under Article 21 of the Constitution of India has been violated due to such prolonged incarceration. On the other hand, Ms. M. Deka, learned counsel for DRI, has vehemently opposed the grant of bail to the present petitioners on the ground that the quantity of contraband seized in this case is huge quantity of heroin and is a commercial quantity, and therefore the embargo of Section 37 of the NDPS Act is applicable to this case. She has submitted that a coordinate bench of this court has not allowed the prayer for bail under such circumstances even though the petitioner in that case was detained behind the bars for more than 4 years. She has produced a copy of the order dated 14/7/2025, passed by the coordinate bench of this case, this court, in bail application number 1918/2025 in support of her submission. She also submits that in this case, the charges were framed on 2/9/2024, and the already 2 witnesses have been examined, and third witness has also been examined in chief, and only 9 witnesses are remaining, which would not take much time. I have considered the submissions made by learned counsel for both sides and have gone through the records available before the court. Court para 17 from bail application 3881/23, 18, 19, 20, 21, 22, 23, 24. Though in the case cited by learned counsel for the BRI, the coordinate bench of this court has rejected the prayer for bail. Even though the petitioner in that case was detained behind the bars for more than 4 years. However, the said court has done so after coming into a finding that the delay occasion in that case cannot be termed as inordinate, so as to violate the fundamental rights of the petitioner in that case. Every bail application has to be dealt with in accordance with the facts of that case. And if the facts are not similar, the judgment of the order of the coordinate bench ipso facto would not be applicable to the facts of this case. This court, in view of the ruling cited in the foregoing paragraphs, is of the considered opinion that in the instant case also, the facts and circumstances are such that the period of 1 year 7 months undergone by the present period of detention of 1 year 7 months undergone by the petitioners may be regarded as long enough to outweigh the embargo of Section 37 of the NDPS Act 1985. Stop. This court is therefore of the considered opinion that the petitioners are entitled to get bail in this case on the ground of prolonged incarceration. In view of above, both the above named petitioners are allowed to go on bail of rupees 2 lakhs each with 2 sureties of like amount, one of whom should be a government servant residing within the state of Assam, subject to the satisfaction of learned.
But can it be a government servant, my lord, because they are from Manipur, even they can have central government people working in the armies and everything. Just government servant, my lord, perhaps, because government servant all over the country are almost, my lord,
Government servant,
that state of Assam may not be
state
there.
of Assam, continue.
I'm obliged.
Subject to the satisfaction of the trial court with following conditions. Conditions same as in this case. 388, 3881. this bail application is accordingly disposed of.
I'm deep.
Hello.
Yes,
Yeah, please, Your Lordship. My lord, regular bail application, my lord. This is my lord charge sheeted case, my lord. There are altogether, my lord, 10 prosecution witness, and out of 10, my lord, 8 we are already examined. my lord.
it is a POXO matter.
Yes, my lord. And my lord,
Please say
the
about
petitioners,
this.
they are, my lord, behind the bar for 2 years, 4 months. More than 2 years, 4 months.
Scan copy was called. for,
Trial
but
court
not
records
received.
were called for. Which court?
My lord, special just POXO Borbetam.
Heard Mr. This is item number,
Item 22, my lord.
heard Mr. S. A. Ahmed, learned counsel for the petitioner. Petitioners, how many petitioners are there?
Two, my lord.
Also heard Miss N. Das, learned additional public prosecutor, as well as Miss R. H. Chaudhary. You are legal aid counsel or engaged counsel? Learned counsel for respondent number 2. On perusal of the office note dated 22/8/2025, it appears that the scanned copy of the trial court records, which were requisitioned in this case, have not yet been received. Issue reminder for the same. Let this case be listed on 11 September.
Lord, can it be on 10, my lord?
10 September.
Offline. Item 24.
So definitely possible for a time being.
After something.
Item 26.
May I please, your lordship. I was in interim, I appeared, lordship, and statement recorded. 73 years old man, lordship, only 11.8 gram of ganja, lordship.
I have a submission, Lordship. Lordship, in spite of repeated communication to the concerned police station, Lordship, they are not taking back the case diary. So,
Taking back the case diary.
for updation, Lordship, it was, I personally submitted before Lordship that the CD may be updated on a number of occasions, Lordship. Then we communicated Lordship, they are not responding. So I am praying Lordship that Lordship will kindly ask the IO to be personally present before the Lordship and explain why he is not complying with your court's order, Lordship.
Lordship,
He's
in
on-
that
he's on
case,
interim, Lordship, let him be on interim, Lordship.
no, lordship, in that case, my bail application may be absolute, lordship.
Lordship, it is-
Because 73 years old,
You have-
lordship,
you are
suffering from
communicating-
several diseases, lordship.
No, you are on interim bail, you will not be.
That time, Lordship, on the last order also, Lordship, I had submitted, Lordship, that the case diary needs to be updated.
Which police station?
From Obhayapuri, Lordship, Obhayapuri police station.
Now, what is the process here? Who takes back the case diary?
We communicate to the concerned police station, they send someone, Lordship, to take back the case diary. So that has not been done on a number of occasions. We have communicated, Lordship, since from a long time, Lordship, it has not been taken back, Lordship. We have communicated on a number of occasions. Because, Lordship, the entries that are in the case diary, last entry is of March 2025.
Heard Mr. J. Samuel, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioner was granted interim bail by this court, by a coordinate bench of this court on 26/2025, and thereafter he has appeared before the investigating officer, and his statement were also recorded. Statement recorded, you know,
My information, it is recorded.
because case diary is here.
Then Lordship, in that case, it is also possible that someone written this
Supplementary
statement
case.
there. It may be also possible.
That is why Lordship, the CD is up to
The
Generally, Lordship, what happens after receiving interim pay order,
learned, on the other
visit the
hand,
police station and they
learned
report it.
additional public prosecutor has submitted that the on several occasions correspondence were made with through
WT message is sent normally. Lordship.
through WT message to the investigating officer of this case to depute someone to send to take back the case diary. However, in spite of repeated requisitions, no one has been deputed to collect the case diary of Abhayapuri PS case number 52/2025. Stop. This approach of the investigating officer cannot be appreciated as if case diary remains in the court for a long period, it would certainly impede the investigation. Hence, let a report be called for from the superintendent of police, which
This should be Bongaigaon.
Bongaigaon, SP Bongaigaon.
SP Bongaigaon, as to why, in spite of repeated reminders to the investigating officer for collecting the case diary by the office of public prosecutor of this public prosecutor, same has not yet been done. The report should positively reach this court on or before the next date fix. Let this case be listed. Let us see the report. Let this case.
I will insist Lordship, the IO and even the OC to be personally present.
No, it is SP should know what is happening in his district.
It should be there, Lordship. I have no objection to that, Lordship. In addition to that, Lordship, let them be also present here, Lordship.
No, we'll call the SP if he fails to ensure.
Ground reality is, Lordship, if the IO is made to appear here, that will be a
No, it will not remedy the.
No, it
It will remedy this present case only.
We have seen, Lordship, a number of police stations where the IO was not responding. Once they appear, Lordship, immediately they become prompt, Lordship.
Now let us see what report we get. Let this case be listed again on 11th of September. Let a copy of this order be furnished to learned additional public prosecutor to forward the same to the SP concerned. The interim bail granted to the petitioner shall continue till next
Lordship,
day.
no coercive action to the petition.
You are on interim bail.
Lordship, this order is passed now. Now, when I will appear, they may torture me.
No, you need not to appear. You said that you have already appeared.
Appeared, but the CD is here. Then again, they will say, we have to take your statement again.
You
And after
cooperate.
passing this order, they can torture me, Lordship. This is practically fake, Lordship.
No, if they torture you, you seek appropriate legal remedy.
All right. Obliged, Lord.
Item 24.
May I please? My lord, it is an application of 483. I take your lordship to FIR at page 13. Well, one FIR was lodged by Drishti Day with the allegation that on telephonic call she received her husband that and demanded some money, madam. And introduced himself as Major Adjournment Assam. That is from the Ulfa Independent and made a monetary demand. Then, my lord, accordingly, my lord, case was registered.
Yes, there is there. Okay.
And one main culprit, my lord, his cousin brother, Saifuddin
Saifuddin
Ahmed was arrested and he has been, after a long detention, he has been enlarged on bail by the court below. Now, my lord, this petitioner, she is a woman, widow, my lord, having one daughter, my lord. Unfortunately, her mobile, this SIM was taken by this her cousin brother, and it was used by this cousin brother, my lord. That's why, my lord, she has been implicated. But in the FIR, her name is not there. Specific name is there, my lord. So, my lord, police called her many times in the police station, and she cooperated, my lord. And ultimately, my lord, she was her husband died, my lord. She got an MSCT compensation. Then she is a shopkeeper of the.
When were you arrested?
Pardon, madam? Arrested, madam. She is the 21/7, madam. Today, 38 days, madam. And nothing, objection has been recovered from her. Actually, there was a suspicion how she has purchased a land at Dibrugarh at the by consideration of 40 lakhs, madam. She has given all details, madam. If she sold the land, she took the land, she got the MSCT compensation, and with this, she has purchased the land at Dibrugarh.
Yes.
Lordship, materials are there, Lordship. Other co-accused, Lordship, Saifuddin, Lordship. His bail application was rejected by this Honorable Court, Lordship, or as per order that is 7/25. And Lordship, this petitioner assists the accused person, Saifuddin Ahmed, to assist band organization Alpha by providing her SIM cards and bank account etc.
No, whether this Saifuddin is a member of Alpha or
Yes, Lordship.
he is to project himself as Alpha.
That Saifuddin has.
Saifuddin, and this petitioner assist this Saifuddin, Lordship, by providing SIM card and also by providing the phone numbers. And Lordship, other statement of other co-accused, Lordship, Banti Saikia, Lordship. From his statement, it is come to that the case is clear that in instigation of Saifuddin Ahmed, Foizun Nesha deal with land for Saifuddin and collected contact number from different person and sent to Alpha by Saifuddin Ahmed for his personal gain. And statement of witnesses also there, Lordship.
That I have admitted, my SIM card has been taken by my cousin brother, and he has used that, for which I am now entangled.
And she provided, Lordship.
I
This
provided.
petitioner provided, Lordship.
What is the punishment for 308?
308, it is up to 7 years.
And 1013? 10 and 13.
10 is not less than 5 years. And 13 up to 7 years, up to 7 years.
UAPA Act is there.
She has become the
Section
victim of
10 and 13
circumstances.
of UAPA Act, Lordship.
But punishment is what is the punishment?
10 or 7 years, hello. See the book, kindly see.
13?
13 is 7 years, madam. Extended up to 7 years.
Less than 5 years, which may extend to
Up to 5 years.
imprisonment for life and shall also be life.
Kuntu.
10.
10.
10.
10.
10.
Roman 2.
Roman 2. Punishable with imprisonment for a term which shall not be less than 5 years, but which may extend to
Not less than 5 years,
life.
but may extend to life. But
There is no material against me, my lord.
Materials are there, Lordship, in the case.
It is a fact that my SIM
Lordship
card
only
was used
pays
by
the
my
city,
cousin brother.
Lordship.
But-
Sufficient materials are there, Lordship.
But I have not telephoned or how I have helped man. Only I am involvement is only for SIM card.
Analyzed report is there, Lordship. Statement of witnesses are there, Lordship.
No witnesses named me. Every witness said,
Statement of victim
say the
was there,
Saifuddin.
Lordship. And earlier also, Lordship, co-accused bail was rejected by this honorable court.
No, I think court below has granted him bail. I have been informed, my lord. I do not
Lordship,
know.
I kindly perish the order. And one letter of Alpha demanding 10 lakh also is there in the case diary, Lordship. Kindly perish.
He is a fake person, not belongs to Alpha member. Saifuddin is a
And
fake person.
she is assisting the Alpha members by providing all the details of the victims, Lordship.
No, I provide, I am
This is not a
helping
fit
because
case of
my SIM
anticipatory.
card was taken by my
Only 39
cousin brother.
days.
Otherwise, there is no other way helping.
Where is life imprisonment?
Roman 2.
In 13,
10.
13,
10.
Roman 2, my lord.
Roman 2. In any other case, shall be punishable with imprisonment for a term which shall not be less than 5 years, but which may extend to imprisonment for life and shall also liable to fine.
but here the accusation is only of assisting the alpha.
Yes,
That will not come under NB. Whether it will come, facts are
Yes.
okay. Heard Mr. S.C. Bishwas, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioners, namely Faizun, alias Faizun Nisha, who has been detained behind the bars. Who is detained behind the bars
from 21/7.
since 21/7/2025, within bracket for last 38 days, in connection with Moran PS case number 62/2025 under section 308 within bracket 5 of BNS, read with section 10/13 of the Unlawful Activities Prevention Act 1967. The gist of accusation in this case is that one, where is the FIR?
FIR is page 13. Page number.
Thirteen is not the FIR. It is only an endorsement of the OC.
No, please come to next page, madam.
This is the endorsement. Where is
No,
the
there is another page. Please come, madam.
Which page?
Well, it is in my page 13, but it was dropped. I have seen it is repeated, 13 in both the pages. That is the adjournment of the last end. So that's the 13, my lord. There is a wrong in page nation. Page 13, please come to the officer in charge, Moran Police Station.
Is not there.
May I verify?
You annex.
I may verify. Excuse me, I may verify.
Otherwise, we'll fix it tomorrow.
Let me see, my lord. I hope I can show you. This is the mistake done by my clerk, my lord.
The form is there, which is not legible.
Yes, sorry, it is not
You
there.
file it.
Right there. Otherwise, you lot can verify it from my copy. In my copy, it is there.
क्या लिखा? Is that on 5/6/2025, one Dhriti Sundar Day had lodged an FIR before the officer in charge of Moran Police Station that he has that inter alia alleging that on 4/6/2025, the wife of the informant received a WhatsApp voice message on a mobile number from a mobile number mentioned in the FIR. The caller introduced himself as Major Adyaman Assam from the Alpha Independent and made a monetary demand. It is also alleged in the FIR that after that, several threat calls were made to the informant by the said mobile number. So, Learned Counsel for the petitioner has submitted that the petitioner is innocent and is a widow and is not involved in the offense alleged in the FIR. He submits that one Saifuddin Ahmed, who is Saifuddin Ahmed?
Cousin brother.
Who is the cousin brother of the petitioner, had taken the SIM card of the mobile of the petitioner and has utilized the same to commit offense alleged in the FIR. Learned Counsel for the petitioner has also submitted that the said Saifuddin has already been arrested by police. You went to police station?
Yes, many times. Because I was interrogated like anything. Then they searched my house. Nothing was found. Then they caught me that I have purchased the land at Dibrugarh.
Learned Counsel for the petitioner also submits that the petitioner before her arrest in this case was called by the police on several occasions, and she cooperated with the police by going to the police station as and when she was called. He submits that, learned counsel for the petitioner further submits that the petitioner got some amount
From motor accident
of
claims tribunal.
money as
the death of her husband.
compensation in a motor accident claims case filed by her on demise of her husband in a road accident. And that is why the police has suspected her of involvement in the offense alleged in the FIR. Learned counsel for the petitioner submits that the petitioner is ready to cooperate in the investigation. On the other hand, learned additional public prosecutor has opposed the grant of bail to the petitioner on the ground that there are materials in the records in the case diary to indicate, which indicates that the petitioner had willfully assisted Saifuddin, his brother Saifuddin, her brother Saifuddin, who used to threaten innocent person and demand money from them in the name of Alpha. I have considered independent witnesses are there. But do you require her further interrogation?
Yes, Lordship.
Stop. I have considered the submissions made by learned counsel for both the sides and have gone through the case diary of Moran PS case number 62/2025. Though it appears from record that there are some incriminating materials against the petitioner in the case diary. However, from the facts revealed in the case diary, as well as from the offense which are involved in this case, it appears that maximum punishment which may be which is provided for alleged offense is not more than 7 years. Stop. It is pertinent to mention herein that the offense mentioned in section 10 within bracket B within bracket Roman 2 has not been made out in this case. Under such circumstances, considering the period of detention undergone by the petitioner, as well as considering the fact that the petitioner is a lady, her further custodial interrogation, further custodial detention does not appear to be necessary if she cooperates in the investigation. In view of above, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the
Chief Judicial Magistrate.
Chief Judicial Magistrate Dibrugarh with following conditions. number 1 and number 2. Send back the case diary. This bail application is accordingly
Develop.
disposed of. Itu ঘুরাই দিও।
27.
It is not similar, this is an interim.
I need to,
Yeah.
updated CD was called for on last.
Up to the CDM.
You are on interim.
Yes, my, your lordship has given me in my last.
Heard Mr. P. Kotoki, learned counsel for the
Right.
petitioner.
For that.
Also heard Mr. K. Parashar, learned additional public prosecutor, who submits that, who prays for some more time for producing an updated, up-to-date case diary. The prayer is allowed. Let this case be listed again on 10th of September. The interim order shall continue till next week.
Item number 30.
None has appeared for the petitioner on call. Let this case be.
My lord,
It is
earlier
there.
also petitioner's counsel not, it is prayed that he is not well because of that fix today. Otherwise, from the interim order was passed, my lord, petitioner has not appeared, and it is also very bad case, my lord.
We'll fix it after 2 days.
My lord. He 13, this is 13 number case in Assam against him, and few cases were rejected. Then he went to West Bengal. When West Bengal, he
That vehicle, purchasing vehicle and
Please, I'm sorry, actually. This matter with regard to the FIR, which has been in this case, in my learned friend was submitting, I just heard. It was with some other cases. Fine, there are many cases, I do not deny that. But with regard to particularly this case, the allegation your lordship will file in the FIR, it was very specific with regard to a car. And if your lordship will kindly turn to page 11. And your lordship also has given interim in this matter on the basis of that.
you are on
The-
interim.
But he is in custody in another case. So he has been given.
You are in jail now.
No,
West Bengal.
not West Bengal. West Bengal.
No, where are you now? In West Bengal or in Assam?
In Assam. Assam, no? Here, your lordship, what has happened? The allegation basically with regard, there were 3 allegations. 3 amounts have been given, but only 1 FIR has been lost by one person. The other 2 person has not lost any FIR, though he has stated this page 11. This is the lordship will see here.
When were you arrested?
He was arrested in the other case, your lordship.
No, whether you have appeared in this case. You have not
No,
complied.
no, he cannot appear because he was already arrested, your lordship. And in fact, as per Dhanraj Swani's case, interim can be granted in a pre-arrest bail can be granted even if the person is arrested.
But you have to comply with the condition.
That is condition, in fact, cannot be complied because of the fact that he is in, because as and when he will be granted bail or he is discharged, he may appear in that case. This is the issue. And secondly, your lordship, here the issue is very limited to only one point, that with regard to an amount of rupees 1,30,000 that has been taken from him, and with regard to providing a new Innova car. And the other 2 amount that he has stated was with regard to some other persons, Montu Bormon and another one, Horace Das. And in this case, your lordship has given only 55,000 for 2 months rent. Subsequently, he did not pay the money. This is only the allegation in this case. Rest cases, whatever is the allegation, I am not concerned with that. But this case particularly, your lordship, the allegation is very simple, is that 1,20,000 taken for a Innova car, and the other 2 amount we are not concerned because those 2 persons have not alleged anything.
Where are you detained now?
Now he is detained in Guwahati.
Guwahati jail, central jail. In which
In
case?
case of Lata Sil PS.
The Tahsil PS case number
54 of 2025.
yes, Mr. Parashar. He is already in jail.
My lord, that 54 case, that is also same. Allegations are same. He is a habitual offender. Here also Siaskar, he take 5 lakhs. Subsequently, agreement was made and he has taken the car. Subsequently, he sold the car somewhere, my lord. When this petitioner, my lord, 12 case in Assam. Now, this present case, adding this present case, this is 13 case. Now, when Malad, he is absconding in all cases, Malad, though the several cases, Pan Bazar, Basista, Sanmari, Paltan Bazar, Rangia, Patasar Kusi, Bazali. When Latasil, that bail 54/25, AB was rejected, then police searching him, police track his mobile and found that he is in West Bengal location. Then police contacted the West Bengal police, then a Naka checking was made. During that Naka checking on 3/6/25, he tried to hit the police personnel, then police fired. Zitu Rai. One Zitu Rai opened fire. Dharmeshwar Rai Orofe Zitu Rai. He is the same person. He, Dharmeshwar Rai, alias Zitu Rai, he fired in a police team. Subsequently, police arrested him on 3/6/25, and another case in West Bengal was registered because of that incident. Subsequently, now maybe taken into custody in that Latasil case. My lord, so far in the case, there is, my lord, 3 cases, my lord, bail rejected. In some cases, maybe, but he was caught after that Latasil case when Naka checking was made at West Bengal, my lord. Vaishnav Nagar Thana, there 658/2025.
What was the date of his arrest?
3/6/25. And that was the date of arrest. And when they here moved the petition on 13/6/2025, they have not mentioned that he is already arrested. He was arrested on 3/6/25. Interim was granted on 13/6/25. At that point of time, it was not mentioned that he is already arrested. And that's why they have taken the interim order. No value, my lord. When the habitual fraud, my lord, 13-14 cases behind him, my lord. And all along same allegation, my lord. I have 3 order copy in the case. There is also all along same allegation, my lord. He took cards from the persons, my lord, giving assurance that with the agreement on all this, he will provide rent. Subsequently, he may sold to others and stop providing the rent and etc.
With regard to the not mentioning about the arrest, your lordship, it has been stated in para 6 itself. It may not have been argued, I don't know, but it's there in para 6 that he has been arrested on 3/6. And here I am, with regard to what my learned friend has been submitting, is submitting with regard to so many other cases. At least what is the status of this case, your lordship? At least he should point out that this case, this is the issue. Here the issue is very clear, your lordship. The FIR does not make such a huge allegation. It says that there were 2, first, your lordship, one car was taken, that is Swift Desire, that was not working. It was returned back. It was not that he has taken away the car. It was returned to be old vehicle and it is not working. And that is why to provide a new Innova vehicle. And for that he has taken 1,30,000. That is the allegation in this case. And with regard to he took amount of so-and-so from Montu Bormon for 20,000 from Horeswar Das. He made an agreement. These things, your lordship, was with some other persons, but those were not, your lordship, that FIR, they have not raised any FIR. Filed any FIR in this case. And this is, your lordship, and in fact, in 11 months, he paid 55,000 and the rest has not been paid. This is, and his only thing is that he has misappropriated the money. That is what they are saying. And if they are concerned with the money, they can always go to this, and it's a civil nature case, your lordship, taking into consideration only the money part.
In this case, whether he has been arrested.
In this case.
In this case.
In this case, now, interim order is there, my lord.
No, but interim order show is that if he is arrested.
That latest instruction we have not received because CD which has since
Whether he has been found arrested before passing of the interim order.
As per my instruction.
before passing of the interim order, no.
Now also, even after passing of the interim order also, he has not been.
And when he was, CD which has from 14/8, my lord, when he was taken in that Lotasil case, that is not reflected in the CD, my lord. As per the case diary, my lord, and that car also, Maruti Suzuki Swift Desire 7101, that is not yet, my lord, recovered, my lord.
No, you take instructions.
Oh, yes,
Because in this case, he is yet to be arrested.
yes. I
He
will take it.
heard.
If already arrested, then it will be instructions. It will be.
No, if now you have to only show him arrest
Yes, yes.
Shown arrest.
Shown arrest.
in this case, because he has already been
Already-
arrested in a different case. And because of the interim, you have to allow him to go on bail if he is arrested.
But at that point of time, it was not the argument of the council that, yes, I have seen now the paragraph on it, that he is already in the custody in
No,
3/6.
this is mentioned in the orders also. It was argued also
I have
in
not-
para 5 of the order. Heard Mr. Y.S. Mannan, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioner was granted interim bail, interim anticipatory bail by this court by its order dated 13/6/2024, 2025. However, as the petitioner was already detained behind the bars in connection with Vaishnav Nagar PS case number 658/2025, he is not yet arrested in the present case. Neither he has been sure whether he has been any prayer is made before any court for allowing showing him arrest in this case. Shown as arrested in the present case. Learned counsel for the petitioner submits that in the present case, petitioner took an amount of rupees 1,30,000 from the informant on an assurance of providing a new Innova car to the informant. However, it is alleged in the FIR that he has not paid he has misappropriated the money which was given to him. Stop. Learned counsel for the petitioner has submitted that the petitioner is ready to cooperate in the investigation as and when he is arrested or shown arrested in the present case, that is Nunmati PS case number 22/2025. And therefore, the interim bail granted to him may be made absolute. On the other hand, learned additional public prosecutor has produced the case diary of Nunmati PS case number 22/25 and has vehemently opposed the making the interim bail absolute on the ground that apart from apart from this case, there are 12 other cases pending against the petitioner throughout the state of Assam, where he has duped the innocent customers by promising them to deliver vehicle after taking money from them. He has also submitted that the petitioner, after coming to know about the lodging of the FIRs against him, has absconded to the neighboring state, that is West Bengal. And on 3/6/2025, he was intercepted at a Naka checking point where the petitioner did not stop when he was asked to do so by the police. It is also submitted by learned counsel, learned additional public prosecutor, that the petitioner had also shot fire from the firearms at police. However, somehow he was apprehended and presently he is detained in the Guwahati jail. Stop. I have considered the submissions made by learned counsel for both sides and have considered the case diary and also have perused the case diary of Nunmati PS case number 22/2025. Though the acquisition in this case is only non-payment of rupees 1,30,000 to the informant. However, considering the fact that several cases of similar nature are pending against the petitioner and he had to be arrested by police by applying force, and the allegation that he also fired bullets on the police personnels. This court is of considered opinion that the petitioner is not entitled to get the benefit of a favorable order under section 482 of BNSS in this case. In view of above, the interim bail granted to the petitioner on 13/6/2025 is hereby vacated and the prayer for anticipatory bail by the petitioner is rejected. Let this send back the case diary.
Obliged.
Item 31.
Right, this is the red sandalwood matter, my lord. Mr. Dikshit Gogoi was supposed to appear, but he is in bereavement, my lord. So
Will
let it come up next week, my lord.
heard. The issue is different. Issue is from where sandalwood came. Sandalwood is not in the list, in the schedule. Heard Mr. S. Nawaz, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who submits that this case is handled by special public prosecutor,
Wildlife.
wildlife, Mr. Dikshit Gogoi, who is presently in bereavement. Considering the submissions made by learned counsel, learned additional public prosecutor, let this case be listed again on 4th of September.
Deeply open.
42.
Lordship, my senior is coming in 1 minute.
Okay. Who is your senior?
Pursuant to my lord's interim protection, the petitioner had appeared before the authorities, my lord. On 4 occasions, I've been told, my lord. It's a matter of disproportionate assets, my lord. Petitioner is a retired government servant, my lord. The complaint was initially filed in the year
Yes, Mr. Kotoki. Do you require? There objection?
No objection.
No objection. We'll make it absolute.
Very grateful, my lord.
Heard Mr. M. Borgohain.
Mohanto, my lord.
Sorry. Heard Mr. P. Mohanto, learned counsel for the petitioner. Also heard Mr. P. Kotoki, learned special public prosecutor, CM Vigilance Cell. Learned counsel for the petitioner has submitted that the petitioner was granted, the petitioner namely Kuldeep Das was granted interim bail by this court on
10/7/25.
10/7/2025. And in pursuant to the directions of this court, he has appeared before the investigating officer on more than 1 occasions and has cooperated in the investigation. Stop. Learned Special Public Prosecutor Mr. P. Kotoki has produced the case diary of Vigilance PS case number 17/2025. He has appeared or not and has submitted that the petitioner has appeared before the investigating officer and has cooperated in the investigation. Stop. In view of the submissions made by learned counsel for both sides, and in view of the fact that the petitioner has complied with the directions of this court and has cooperated in the investigation, the interim bail granted to the above named petitioner by order dated 10/7/2025 is hereby made absolute, subject to the condition that he shall continue to cooperate in the investigation. Send back the case diary. This bail application is accordingly.
5/7. I've been told 4 to 5 occasions. Last time it was on 18/8/2025, my lord. Interim this year, DOSA.
Prior to that, he appeared.
Thereafter?
Thereafter also he appeared, my lord. Last time he appeared on 18/8/2025. I've got clear instructions.
No, he has appeared or not?
Second time he appeared on 18th.
Okay, okay. Then it is okay.
Because already appeared,
So we have made it absolute. If you arrest him, allow him to go on bail.
I'm very grateful, my lord.
Perhaps diary not received, my lord.
Heard Mr. A. Paraman, learned counsel for the petitioner. Also heard Mr. A.K. Parashar, learned additional public prosecutor, who prays for some more time for producing the case diary. There is allowed. Let this case be listed again on 8th of September.
Highly obliged.
46 and 47.
On the last occasion, my lord, this scan copy was called for, but I have all the evidence in my criminal appeal. Your lordship will kindly take up item number 36, the criminal appeal number 169 of 2025. Today is for consideration of the bail. Other formalities are completed, my lord. My lord, in this case, my lord, a person has died, but
so far the evidence is concerned against this accused appellant, who is Anwar Hussain alias Anwar Bepari, your lordship will kindly
What was the sentence imposed?
8 years for section 307 and for the simple heart 2 years. Your lordship, I'll take it directly to the only one statement which appears against the accused. Your lordship will kindly see, then I will take it to the genesis of the whole incident and all. Your lordship will kindly see page 73, the PW number 8.
'73 in which file?
In criminal appeal number 169 of 2025. Item number 36. Main appeal. The paper book. Your lordship will kindly see page 73.
Yes.
Now your lordship will see from the first 3 line also, I'll read it. I know the informant, I know the accused person. On the date of occurrence at around 8:30 p.m., after closing my shop, I along with Shahid Ali were going to the house of Shahid Ali with a gas cylinder. When we reached near the house of Anwar Bepari, the accused Kalam suddenly came there and inflicted a blow with a dagger in the abdomen of Shahid Ali. We are not here for Kalam. Kalam has been sentenced to life. Accused Sabur Ali inflicted a blow with a knife on the backside of the head of Shahid Ali and he sustained injury. We are also not for Sabur Ali, who has been also sentenced to life imprisonment. Then all the other person attacked Shahid Ali with sharp pointed weapon, inflicted injuries on the backside of Shahid Ali. When I tried to rescue Shahid Ali, accused Sabur inflicted a blow with a knife on my hand and I suffered injury on my left hand. The accused showed the injury mark on his left hand wrist. Now the allegation which for the first time in the court has come against this present petitioner is this, madam. The accused Anwar Bepari.
You are Sabur.
No, Anwar Bepari. Those 2 accused who has caused the fatal injuries, we are not for them. They have been sentenced to life, my lord. We are for this, my lord, page 74, the second line. This is the only allegation against me, my lord. The accused Anwar Bepari inflicted a blow on the backside of my head. Now your lordship will see the deposition of the doctor PW5 in regard to this injury, because this is the only allegation against Anwar Bepari that your lordship will find at page 67, the deposition of the doctor. And your lordship will note that the name of the PW 8 is Bakkar Ali. This Bakkar Ali's injury, your lordship will find at page 67.
Yes.
Bakkar Ali, PW 8, cut in the left forearm, cut injury in the scalp, 2 inch into half-inch bone dip, 2 inch, half-inch is very small. Opinion fresh, simple, caused by sharp weapon. So this is because of this simple injury, my lord, I have been sentenced to 2 years in jail. Now, so far, page 74, now your lordship will see the, because I have to prove the contradiction. Now, this contradiction, I have proved it through the IO. Your lordship will kindly look into the statement of the IO at page. Oh, just a moment. At page, it starts from page 90. The IO is PW 12. What is not Korean? This is Korean. Page 90. PW 12.
90.
It starts from PW 12. Now you'll also look at page 93. The contradiction was put, madam.
Yes.
The page 93, the second paragraph. Bakkar Ali PW8 did not state before me that Anwar Bepari inflicted him injury on the backside of his. So this was the statement which was attributed to the accused Anwar Bepari in the examination in chief. This was made for the first time in the court, and we have proved it through the IO, the contradiction. And your lordship has seen from the injury report of the doctor that this PW8 Bakkar Ali has only sustained simple injury. Now your lordship will see
there is another connected read.
Simple injury on forearm and
It's superficial, my lord, and it's not directly attributed to any accused, my lord. Your lordship will see at page 67 again, cut in the left forearm, cut injury in the scalp, 2 inch into it, a half-inch bone depth. No dimensions, depth, length, breadth, how it is not there. So the doctor said that it is simple caused by sub-organ. For that, your lordship will see at the final hearing whether I am liable to be convicted under for 2 years or 8 years. Now your lordship will see the other accused. In the second case, your lordship will look it from here only, the evidence of the PW7 which implicates the second accused.
second accused means in next.
Yes, page 70 is PW7.
Yes.
Now from page 70, your lordship will find 1, 2, 3, 4, 5, 6, 7, 8 line. Accused Sorab inflicted injury on my left arm with spear. Your lordship got it, my lord? Accused Sorab. This accused name is Sorab. Sorab Ali. So this is the allegation, only allegation against him is, against Sorab is accused Sorab inflicted injury on my left arm with spear. Now, against this statement, my lord, which have been made in the examination in chief, your lordship will kindly now again see the injury report at page 66 and 67.
Yes.
66. Manikulla Sigda. PW7, my lord, is page 66.
66 in here is Biprajit.
No, in the same paper book only, your lordship will
Robin
look at
Sharma.
this Anwar Hussain paper book.
Manikulla Sigda, yes.
Yes, Manikulla Sigda. PW7. Cut injury in the left elbow, 3 inch into 2 inch into 1 inch. Abrasion in the chest, 1 inch into 1 inch. Then fracture on the ulna. Ulna is, my lord, it's in the forearm. Since it was a fracture in the hand, that's why, my lord, the first 2 injuries were described as simple, and since it was a fracture, that's why it is said grievous. Because if and it is not on the vital part of the body, it's on the forearm. But whatever be it, my lord, this is the allegation against accused Sorab, my lord. Now your lordship will see the FIR, my lord. At page 20, just for reference, my lord, your lordship will give a cursory glance at the FIR at page 20.
Yes.
Now, this is an FIR of 11/12/2013. As many as 13 accused were roped in, my lord, all persons.
Yes.
In the FIR, your lordship will find that the allegation was made against all the accused. Accused number 1 was specific injuries on the head, and accused number 2 to 13, they have made it all against the sharp weapons. Later on, my lord, they developed it during the trial, they attributed some specific injury to particular accused. Then the postmortem report is at my lord page. The injury reports I have already shown it to your lordship at Annexure 3. Your lordship will just give a glance at the postmortem report at page 37. This is the disease, my lord, and your lordship has seen from the statement of those 2 witnesses, because the others are all hearsay witness. I will take your
lordship took a quick reference to those statements. But basically, this person who has died because of the injury caused by that, my lord, Saeed Ali and my lord, Sabur Ali. So we are not against those persons who have caused the death of the deceased, my lord. Now, your lordship will give a quick glance of the deposition of the hearsay witnesses from PW1 at page 62.
No, what is your submission?
My
In
submission
case
is-
of the first,
Accused, my lord, your lordship has seen
that
the
there is
primary-
contradiction.
There is contradiction first time in the court, and the injuries are also simple. And it was since, my lord, the injuries are simple and all, my lord, at best, if I am convicted tomorrow, then I will have to undergo at only for 2 years in prison if your lordship decides to appeal that conviction. So that for that case, your lordship will kindly consider the bail, because from the date of the impugned judgment, I'm in custody. 11 months I'm in custody. Out of that 2 years, if your lordship ultimately decides to afford. Now, so far the other accused is concerned, my lord, who has caused the injury on Manikullah Sigdar.
There are materials that he suffered
Fracture in the
hand.
hand. Now, if your lordship looks into the evidence of PW7 once more again, my lord.
Page number?
Page number 70.
Yes. Yes.
I know the informant of this case. I know the accused person. On the date of occurrence at around 8 AM, while I was about to sleep, I heard hue and cry near a field, and accordingly I went out. Large number of people had gathered there. They informed me that
That
is the
contradiction little bit there, but regarding Saurabh Malad, the injured himself stated regarding Malad, and it is corroborated in the Malad injury report, Malad statement in the of the doctor also Malad. So regarding Saurabh Malad,
only thing is that so far they are this Anwar Hussain. There is also another factor is that he is a man of 64 years and he is medically, he is not well. We have given his medical certificates and all in the eye. And so far, my lord, Saurabh is concerned, my lord. If your lordship ultimately at the end of the day holds that he will be convicted for 5 years or less than 5 years, so out of that he has now undergone 11 months, and I don't think, my lord, this appeal is likely to be heard immediately. If it was on day one, my lord, I would have not asked, but considering the pendency of the appeal, I don't think, my lord, this appeal will be heard, my lord. Ultimately, at the end of the day, if your lordship hears in and find him that he is for causing injury on the hand, then your lordship may modify or appeal the diploma.
I'll go through the records.
Yes.
Heard Mr. B. D. Kaur in item number, both items.
36 and 37.
B. D. Kaur, learned senior counsel assisted by Miss H. Busho, learned counsel for the applicants / appellants. Also heard Mr. K. Parashar. Let this case be listed for delivery of orders on Tuesday. Tuesday is 2nd of September.
Yes, ma'am. Obliged.
2nd September.
Okay, notice was issued on 15/9. We have immediately taken steps. Perhaps it has been served. LCR was called for and it has come.
15/9 or 19/5?
Sorry, 19. 19.
19. Who is appearing for?
None, man, for the respondent.
Notice me, user process has been. Service report is not there. only report that it has been issued. Who is the respondent?
Sole respondent, my lord. He's from Panipat, Haryana.
What is to be done? You will take fresh steps or we shall await?
Take fresh steps.
Yes.
Otherwise, they have knowledge, my lord, because before the trial court, we are appearing.
Heard
They are also
Mr.
appearing.
Heard Mr. N. Nath, learned counsel for the petitioner. On perusal of the office note dated 18/8/25, it appears that the records of the trial court have been received. However, there is no report regarding the service of notice issued to this sole respondent. As regards the service of the notice issued to the sole respondent. So, learned counsel for the petitioner has submitted that the petitioner took steps for issuance of notice upon the sole respondent on 19/5/2025 itself. However, stop, as much time has lapsed since then and no service report is there. This time you produce the track consignment report of the after taking steps. Kanika? There, the petitioner is directed to take fresh steps for issuance of notice upon respondent, sole respondent by registered post with AD, as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. You have an interim?
No, man. That's the difficulty, man. That's the difficulty.
Stop. List accordingly. Face the difficulty for some more time.
Applicant is convicted under section 16, read section 4(1) of the.
Why it is in the orders column today?
The IA is their lordship. Suspension of sentence. The service upon respondent number 2 has already been completed. Mr. M. Sharma has entered appearance for respondent number 2.
It is a POXO case.
POXO case, lordship.
Who has appeared?
Mr. M. Sharma.
Who is M. Sharma?
Maharshi Sharma probably. Maharshi Sharma.
But no one is present today.
But inform him, your lordship may take it after 5 minutes. I will inform.
Okay, okay, he's there.
Yes.
10 years. You will file written objection.
The objection has already been filed. It's reiteration of the same entire facts of the judgment and nothing else.
Okay, let Mr. Sharma hear.
Lordship.
Yeah, please, your lordship.
Yes.
Duly have taken the steps upon the respondent number 2, my lord. And LCR has already been, a scan copy of the, my lord. LCR has already been received, my lord.
We'll await service report.
My lord. The allegation against the petitioner is, my lord, a petitioner has misappropriated the scholarship, my lord, of the students. Basically, my lord.
NCR or case diary? It is a charge sheeted case.
Yes, my lord. Challenge.
Heard Mr. I. Alam.
T-Sheikh, my.
T. Sheikh. learned counsel for the petitioner, also heard Mr. K. Parashar, appearing for the state respondent. It appears that the notice in respect of respondent number 2 has been issued on 12/8/2025. However, no service report has been received till date. So I wait further. Release this matter after 2 weeks on the date to be fixed by registry.
Date may be fixed, my lord.
After
Petitioner has no any role in the FIR, my. The lordships will testify, my lord, after.
in the 3rd week of September on a date to be fixed by registry. Registry will
Highly obliged, my.
Item 41.
Right, Lordship, I have for condemnation of delay, Lordship, and 92 days.
notice has gone to respondent number 2. Okay, heard Mr. What is the name?
M.A. Mondal.
M.A. Mondal, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. This application under section 5 of the Limitation Act 1963 has been filed by the petitioner seeking condonation of the delay of 89 days in preferring the connected criminal revision, in which the order dated 19/11/2024 passed by learned session judge Kokrajar in criminal appeal number 2024/2023 has been impugned. Issue notice. Stop. Since Mr. K. Parashar has appeared for respondent number 1, no formal notice need to be issued to the said respondent. However, as regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice upon the said respondent by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks.
Obliged.
Item 42.
Please, your Lordship. So in this case, it is a POCSO case, appeal is pending, my dear. Yet to be registered. There is IA, criminal bill 712 for condemnation of delay. Already notice has been issued on previous date, Your Lordship. And office note dated 18/8 may be seen. Notice has been served upon the informant. We are seeking condemnation of delay on the ground of medical ground.
POCSO case.
POCSO case, my lord.
We'll appoint one Amicus curiae if notice is served,
Already served, notice has been served.
but no one has appeared. Heard Mr. D.R. Saikia, learned counsel for the applicant. Stop. Also heard Mr. K. Parashar, learned additional public prosecutor. Office note dated 18/8/2025 shows that notice issued to respondent number 2, supplementary file notice. Okay.
Total 51 days delay.
In other cases, we don't have any objection, but in case of POXO, requirement.
He was convicted for 5 years, my lord. Already behind you are 2.5 years, my lord. behind
Notice
you are.
issued to the respondent number 2 has returned after due service. Stop. Since no one has appeared for respondent number 2. This court is inclined to appoint one amicus curiae to defend the cause of respondent number 2 in this case. Accordingly, any amicus present in the court? Accordingly, Miss M.K. Brown, whose name appears in the list of amicus curiae prepared by the registry of this court, is hereby appointed as amicus curiae to defend the cause of the respondent number 2 in this case. The petitioner is directed to furnish a copy of petition for condonation of delay along with annexures, as well as memo of appeal along with annexures to the learned amicus curiae within how many days?
7 days.
Within 7 days from the date of this order. Registry is directed to reflect the name of Miss M.K. Brown as amicus curiae for respondent number 2 in this case. Let this case be listed on 15th of September.
Highly.
Sentence for a period of 10 years, Lordship, from 6 to 2025. I have not annexed the evidence with my eye, but your Lordship will find that at page 13, because the entire judgment of the learned trial court.
Conviction is under what?
Under section 16, reduced section 4(1) of POXO Act. There are 2 accused persons. I am for the accused number 2. Mazid Langthasa, there are 2 accused, one Mazid Langthasa and second one is the petitioner before your Lordship, Mangchan Bul Chorai. Mangchan Bul Chorai, the petitioner before your Lordship, is convicted under section 16 and Mazid Langthasa is convicted under section 4.
You are for both the accused?
No, I am for the Mangchan Bul Chorai, who was convicted under section 16 for abatement.
Yes.
10 years. So both the persons are convicted for 10 years.
What is your submission?
Lordship, at page 13, the trial court has already reflected the entire evidence. I will just read out the evidence of the informant. The informant is the president of Mahar Women's Association and the PW2, who is the alleged victim.
No, what is your line of submission?
Lordship, there is absolutely no evidence
Against you?
Against me. And there is no evidence to suggest that the petitioner, present petitioner, he instigated the accused, another accused, to commit any unlawful act. That is the only.
What was the reasons given by the trial court for convicting you?
Says that I was driving the auto, wherein all the persons, the victim as well as her friend and the co-accused were going with me. That is the only reason. Since just because I was driving the auto, I am an auto driver by profession. I am living my livelihood by driving an auto. I am just a 27 years old boy who resides in Haflong town, Lordship.
Yes.
And if your Lordship perusses page number 23 regarding the age determination. Page number 23, paragraph number 23. In fact, the birth certificate of the alleged victim was exhibited, but it was discarded by the trial court, saying that the victim was born on 6/9/2025 and the birth certificate was obtained on 25/5/2010 at paragraph number 23. And therefore, under the Registration of Births and Death Act 1969, there is a provision that the birth certificate has to be procured within 1 year. And therefore, the person who issued the birth certificate was not examined, and therefore, the birth certificate cannot be taken into consideration for determining the age of the alleged victim. Now, the basis of determining the age of the alleged victim is the age which is recorded in the 164, in her 164, which she stated before the learned magistrate, and the deposition, in the deposition of the mother of the alleged victim, recorded before the trial court. In her evidence, she said that she was 15 years old. That is the only basis of determining the age. In fact, the trial court said, because trial court discarded the birth certificate based on the judgment passed by our High Court in Manirul Islam versus State of Assam, reported in 2021 Criminal LJ 3339. At serial number 20, para number 24 of the trial court judgment, page number 25. The trial court said that the birth certificate, though it was exhibited, cannot be taken into consideration because there was 5 years of delay in getting the birth certificate, and the medical report of the concerned doctor who examined the alleged victim, it says that she was between 14 to 16 years. So the benefit of 2 years has to be given to the accused. And when the birth certificate was discarded, it was not considered to determine the age. The other parameters laid down under section 34 of POCSO Act as well as read with section 94 of the Juvenile Justice Act, that were not done by the trial court. The school certificate, the school transfer certificate, or the admission register, those were not produced. Not a single effort was made by the prosecution. So therefore, the age of the victim could not be held that she was a minor, though the birth certificate was on record. At para number 26 of the trial court judgment, in fact, learned trial court itself admitted that there were contradictions. 26, 1, 2, 3, 4.
Yes, 26.
Para 26, serial number 3. The last line, while these witnesses corroborated each other on several points, there were also some contradictions in their accounts. The trial court itself admitted that there were contradictions in the evidence of the witnesses.
Yes.
I hold that although all witnesses acknowledge their awarenesses of the incident, the prosecution has not clearly established who first brought the matter to light. And 5, it is evident from the evidence that subsequent to learning about the incident, meetings were convened and the victim and her friend recounted their experiences. The victim also stated that following the incident, she and her friend fled and sought refuge in a house. However, the investigating officer did not make efforts to visit that house or examine the owner as a witness. Both the victim and her friend testified that they returned to their village with assistance from an individual named Domseng, yet the investigating officer did not examine him as a witness, a fact he admitted during his testimony. So all these are contradictions are admitted by the trial court. Despite that, the petitioner was convicted under section 16 of POCSO Act, saying that there is an instigation by the petitioner to the co-accused to do an unlawful act with the respondent number 2. Sorry, with the victim. Respondent number 2.
What is your name? Firoz?
No, Firoz is the co-accused. I am Mangchonbul Chorai. He is the main culprit.
Yes.
And in their objection also, they reiterated the same facts which is stated in the judgment. So there is absolutely nothing against the present petitioner, Lordship.
Yes, Mr.
6/9/2005. So came Malad on 20th of May 2010. Incident occurred March 2020. Incident occurred 2020, but particular same on Malad. 25. So the date of birth is 6/9/2009. Incident occurred 9/1/2020. The 20 time in her 164 also 164 around 14 years 3 months, 14 years has been given, and in PW positions are reported 40%.
How the age was assessed?
In
On the basis of the
Evidence recorded.
deposition,
Yes.
his submission is that it was not assessed as per section 94 of the JJ. Medical evidence is there.
64 2020 is stated as 14. This 14 are 3 months, it is calculated particular, and when depositions were taken on 4/21, is stated as 15. And murders also stated at point of time. So, it is corroborated, 1 year before, he stated as 14, now in 2021, they become 15. At that point of time, senior,
Yes. Yes.
But in respect of the medical evidence, if I may humbly submit.
No, while considering a 430 application,
Lordship.
I will not meticulously assess the evidence.
Lordship.
Which will be done in after final hearing of the.
Lordship. Absolutely.
If prima facie nothing is against you,
Yes.
then you may get benefit.
Lordship, the prima facie, the age determination is not there. That will absolutely give me the benefit, because once the age determination is not there in terms of the POXO Act, as we read with the Juvenile Justice Act, the benefit has to be given to the accused, because the conviction will not sustain under the POXO Act.
Yes.
And it was then stopped also. So at that point of time, when he made event, it was stopped also. Subsequently, it was stopped in so he subsequently that occurred by.
Okay. Oh, from where you are reading? Page number?
No, that is deposition from the records. Kiman, PW2, hello. Page 14, para number 7. It is the victim statement. And that also your lordship will find that.
No, you put a flag there.
There also the cross-examination part, lordship, in my respectful submission is very much required to be considered, because in her cross-examination, she acknowledged that they had willingly accompanied the auto rickshaw driver, who is the petitioner before your lordship, and confirmed that he did not assault her. It is in her cross-examination. The PW2 is the victim.
No, but his submission is when she shouted and asked you to
Yes.
stop.
Yes.
You did not stop. Okay. Yes. What is your submission? Anything else? Aiding and abetting. Yes. 13 of the IA. Yes, IA code. Yes. Yes. Eleventh of September. The interim order shall continue till next day.
So item number 11, there is an interim order.
Wherever there is interim order will continue. You are praying for withdrawal. Heard Mr. K. Rahman, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. It is submitted at bar that in the case for quashing of which this instant criminal petition has been filed, final report has been submitted, and therefore, why the FR number?
933/25 dated 25/8/25.
Therefore, it is submitted by learned counsel for the petitioner that this criminal petition has become infructuous. Considering the submissions made by learned counsel for the petitioner, this criminal petition is disposed of on becoming infructuous.
My lord, another branch that one judgment was there that may be set aside. My lord. Judgment regarding my lord, Chima of the pet dog. Matter relates to one pet dog. My lord. Still,
In which case?
in this case, my lord, in additional affidavit, we bring it on record, my lord.
No, for setting aside, I have to go through the brief.
Yes, my lord.
Not now. Then we'll take it up. Otherwise, there is no urgency. FR has been filed.
My lord. Yes,
Just a minute. Due to paucity of time, this matter could not go to Katidim.
My lord, item number 10, my lord.
No, just a minute, Mr. Due to paucity of time, this matter could not be taken up for hearing. Let this matter be listed.
Tomorrow, lord.
No, tomorrow. After 2 weeks. Because there is no urgency.
My lord, judgment is there.
After 2 weeks, on a date to be fixed by registry. Yes, Mr. Sonal.
Item number 10, my lord. There was, my lord, that interim order, my lord, suspending the criminal proceeding, my lord, pending criminal proceeding, my lord. And my lord, after the hearing, final hearing, matter was reserved for judgment, my lord, under my lord Justice Pathak, my lord. So because of transfer, this matter has been released, my lord. So therefore, my
It has to be heard again.
yes, my lord. No matter has been released, my lord. This, my lord, this stay, my lord, that may be continued, my lord.
Lordship, how can this stay be continued if the matter is being heard afresh?
No, my lord, after hearing, my lord,
yes,
at the initial stage itself, my lord, stay was granted.
Stay has not been vacated.
But sir, there is a
Stay
order
not,
which
stay
categorically
stay
states.
not vacated, my lord.
No.
And matter was reserved for hearing, my lord. Then it was released, my lord. So after release today, for the first time I am appearing. So my lord, that stay
remains.
My lord, it has to be continued, my lord.
Lordship, the matter was adjourned for verdict, not for hearing.
No, but stay has not been vacated,
Not
not been vacated.
But
You can file a application for vacating the stay. But today we are not hearing the matter, therefore we are extending the stay.
Lordship, as says that the interim extends up to 27/9/24, categorically date. It clearly says, it doesn't say up to next orders or further orders. It says up to 27/9/2024, as clear as.
After that, there was no
It
extension.
was adjourned for verdict, then it was listed again before Justice Chaudhary. Now Justice Chaudhary roster has been changed to civil. Now it is before your lordship.
And that,
When it came up with before Justice Chaudhary, they went for a stay, extension of the stay, but Honorable Justice Chaudhary denied it.
No.
okay, then it has lapsed.
Lordship, it cannot be lordship, the order is there. And lordship.
No,
can pursue.
in this manner, no, none of you would be able to persuade me.
Lordship, the stay was granted.
No, I have understood,
My lord, on that day,
not today.
my lord, I practice in Itanagar bench. So after release, my lord, I was not aware, I did not appear on that day, my lord. So on my behalf, my associate, my lord, sought for a time because when the matter was
But
released.
stay was not extended.
Mr. Basumatari's name appears.
No,
in the
you,
cause list.
if
He
you
can stay.
Mr. Agarwal, if you intervene, if you interrupt, then I will not hear the matter.
I approve.
My lord,
We are fixing the matter short. I will not decide the matter of extending stay now. Because without going through files, it is not possible.
my lord,
You choose a date, we are fixing the matter.
my lord, on that day, my lord, my learned friend is saying, my lord, that my lord, on that day, my lord, no order was passed, my lord. Then.
Lordship, may I make a submission?
Submission.
No, you choose a date.
2nd September, my lord.
2nd September. We are fixing it on 2nd September. You are agreeable to it.
Lordship, I am agreeable to any date this week, Lordship. It is very painful to come from Calcutta, Lordship. A number of time I have come and the matter does not reach, sir.
No, but we cannot help.
If that is, Lordship, I will come on 2nd of September, provided a matter is kindly upgraded, Lordship. It remains at the bottom and we don't find it.
Yes, add 2 on 6.
And Lordship, can 53, 50.55 be tagged along as it was done today?
Yes. Item number 10, 53,
54 and
54, and 55. Due to paucity of time, matter could not be taken up for hearing today. Let these matters be listed on 2nd is okay.
2nd September.
2nd September at 2 p.m.
Lordship, regarding item 21, date may be accommodated. Regarding item number 12, Lordship. Any date?
12 suggested date. 18 September.
Obliged.